All right, it is 9 a.m. and it's Friday, so that's a good thing. Bashan, are you ready for Friday? Norma, you ready for Friday?
Yes. Judge, and breaking is running in about 15 minutes.
Okay,
Judge, how-
all right. No problem. All right, so I'm going to call the docket. You need to let me know you're here. If I don't know you're here, I'm going to assume you're not here, and your Friday is going to turn into a Monday because a warrant may be issued for your arrest. Please come in, have a seat. Thanks for joining us. All right, in custody, we have Clifford LeBlanc. Thank you. Caitlin Martinez. Caitlin Martinez. All right, so everybody who's on the front row is for people who are late. The front row is for people who are late. Usually in church, they make everybody come down to the front row, but. All right, so we're going to start over. Caitlin Martinez. Lisa Quintanilla.
Stand up when she calls, please.
All right, in custody, we have Hillary Stillman. Patrick Vargas. Patrick Vargas. Norma, can you all check to make sure that he's on bond?
Yes.
In custody, we have Reuben Hawkins, Maricela Alonso, Guillermo Rodriguez. In custody, we have Eric Gonzalez Lopez, Frolan Guzman, Randy Lopez, Hector Lopez, Anita Herrera, Jesus Espinoza, Pete Castillo, Victor Garcia, Alexander Castro. Thank you. Nicholas Cornelius. In custody, we have Stephen Miles, Sean Smith. U.S. Marshals picked him up. Norma, that's what I'm having.
Yes, ma'am.
All right, Richard Thomas. Thank you. Kenan Brown.
He's in federal custody, Judge.
Okay. In custody is Jacqueline Wallace, Elsa Vaquera, Robert Reyna, Jacob Garcia, Andres Diaz, Mariah Rodriguez, Daniel Macias, Robert Andrade, oh, come this way. Everyone, just one moment. Why won't that leave? And we are connected, so. Ricky Coleman. All right, where's Mr. Coleman?
He's in custody.
All right, thank you. Jasmine Shaw. Rodrinique Jones. Jacob Moya. Thank you. It's going to be a great Friday. IT came in, fixed the problem, just like, well, they told me not to call them IT, they're court techs. Yeah. Jacob Moya. Jessica Gonzalez, is it cold enough out there for earmuffs? No, my mom would admire that. She always tells me I need some. Caleb Coleman. Caleb Coleman. In custody, we have Hector Hernandez, Jordan Robbins.
Here, Your Honor.
In custody, we have Joshua Benavides. Katrina Mendoza, Jose Ruiz, Christopher Black, Isaiah Vorjou, Brandon Wright. Brandon Wright.
He's gonna be on Zoom, Judge.
Okay. Carlos Vasquez Jr.
Counsel President, Your Honor, I'll find.
Okay. Pedro Alonso. Fernando Carmona. Roland Lopez is in custody. Charles Garley. Christopher Armstrong. Mario Pineda.
Present, Your Honor, check it on Zoom.
Okay. Gracie Segundo.
Present, check it.
They were supposed to be present in court, Judge.
Oh, I told them they got to pay by Zoom. Uriah Huffman. Uriah Huffman. Oh, thank you. David Gallegos, custody. Leonardo Rosales.
Prison with counsel, Your Honor.
Thank you. Jamariah Simmons. All right, anyone came in late or your name wasn't called?
Victor Lucio,
What's your name?
Victor Lucio, LUCIO, supposed to be in the 227.
This is not the 227, down the hallway. You're welcome. You can let them know you were here. Yes. Oh, and let them know you were on time. You're welcome.
They're all for the 227.
Yes. And you're dressed appropriately for court. Yes. I'm sorry, what?
Andres Diaz, he needs to go.
Where does he need to go?
Andres Diaz, he came in late. You're ready.
All right, you need to be on the first row. Yes? First row. Anyone else who was late? Or your name wasn't called? Yes, what's your name?
Acosta. Okay.
I'll check on that.
All right, everyone, when I ask for your name, you need to give me your full name. It's not like it's Cher or Beyonce where you just give that one name and everybody knows what it is. So, Mr. Acosta, we're going to check on you, okay? Do you know who your attorney is?
Albert Acevedo.
All right, just give us a moment. We'll check on you. All right, everyone, these are the rules of the court. I try to keep the courtroom as least congested as possible. You will see files for criminal trial division. Family violence will be here shortly with their file. Just grab their file, place it on their desk. They will confer with you. Have a seat. They will call you in the order of which you appear. Do not approach the court if you have not spoken to your client and conferred with your client. If your client is in custody, you need to let the deputy know they're in custody. When they bring them out, do not leave the courtroom. If you have someone whose English is not their first language and they need an interpreter, even though you may speak their native language, we still need an interpreter to come down. So once an interpreter is requested, do not leave the courtroom because there's a limited number of interpreters. And when they come over here, they go first. So that's the only exception to the court's rule that first come, first serve. If there's an interpreter involved, that person will go first. Today is Friday. Everyone, let's be patient. Let's be kind. Tomorrow is Saturday, so we have something to look forward to. So everyone, let's keep it right here. And everyone, please confer.
Hector Hernandez. He said that he was in China. Showed up shortly. Should be shortly. And then within. I know someone wanted I think it's more important than things. What is that, a third degree or? Let's wait till here and I'll put it the first hand if they would like to see. Yeah, yeah, I mean, probation, I think. Yeah, it looks like. Okay. Yeah, all guys will be able to.
Just walked in.
I understand, but if there's doesn't we call maybe another day? I'm thinking Wednesday next week, does that work for you? Okay. I call my office.
Jason. Jason,
You get a date for it.
She always will tell me. Yeah, I have no idea.
Okay, all right.
Yeah.
Thank you.
Sure.
And good morning.
Yeah,
That's
good
my
mor-
surprise this morning.
yeah, good morning. I'll let mom know.
I'm glad she has her back.
She does. She's always there. Let's just see. Let the attorney know. This is the only time you have to see if they can do it by Zoom.
Greatest weather ever.
Judge,
Yes.
do you want this extra mic? There's two mics already right here, and this one's right here. I don't know where you want this one.
Oh, you can leave it here at the. Yeah, that's fine. Unless it goes on that third post.
I thought it was just.
Yeah, I have no idea. Yeah.
Where do you put the third one? I'm just scared to put it right there. If then goes up to the bench and they forget to turn off the mic. They're coming down.
For 7 you're the 227, down the hall, all the way at the end, other end of the hall.
Yes, I know.
Now put you on it?
Just a
You
moment.
want me on the outside or the inside?
Oh, it's the outside.
Sorry.
Who is this? What's the defendant's name?
Hector Hernandez Jones.
And he's coming back Tuesday. Okay, all right, we'll see you back Tuesday. Thank you. Just 1 second.
If you're coming in late, you need to check in with the court. Because the BF has already been issued, a bond forfeiture has already been issued. Hi.
All right, and are you here on Sean Fifth?
Yes, ma'am.
All right, and where's Mr. Smith?
Apparently, according to normal, he's in federal custody. I'm not even sure which facility this is.
Okay, and were you recently appointed?
I was recently appointed this man, so I don't know anything about this case.
Yes, no, he is in federal custody. He's been in federal custody since October. Jason, her client, Sean Aaron Smith, he's been in federal custody. I've noted on the file since, actually, we've known he's been in federal custody since June.
Okay.
So I don't know if you all can check, and when I say June, I mean June 2021. So I don't know if you all, what your plans are for these cases, but is there any way you can look into that? Sure. All right, so what we'll do is we'll reset your cases. How much time do you need?
Oh, Judge, to look into it, probably just a few weeks. I mean, at less, depends on which burner it goes on.
All right, so you want to, is March 10th enough time for everybody?
I think so, Judge. I mean, I'll see.
All right.
I could probably find out what's going on. I'll send an email off today.
So we'll reset it for March 10th. She's been newly appointed to the case, but you all can exchange contact numbers and you may not need to come back on that day.
Thank you, Judge.
Sure. All right, thank you. Sure.
Yeah. Is it on the?
It should be.
Yes, it is.
You don't know how to read our lips. I even highlighted on it. I don't need a, just put that down.
Well,
Sean Smith, March 10th.
Just a moment. What case are you approaching on?
I'll stay on.
Yes, thank you.
I just want to let you know, Your Honor, he is here. The wrong court.
All right, and who is it?
Oscar Vasquez, Oscar, stand up. Carlos, stand, excuse me, Carlos, stand up.
Okay, all right.
He went with the wrong court. He went to 6 where misdemeanor cases, it's directly connected to the.
Okay,
But, family bonds is not in yet, so I'm gonna run up to 6, but another case. You don't mind.
no, no problem.
Thank you.
Like 20 minutes.
That's how it works.
All right, you can see if it can be zoomed in from Wilson County. Okay,
So I'll call this down today.
all righty.
These are.
So as for basically. So what was request?
Yeah.
Well, I actually.
Yeah.
Sure.
I think she had a motion.
Just give me a moment.
They go off and run after I talk to you, Judge.
Okay, all right.
I honestly. Before I make a signature,
Okay, I got this. Okay.
There's a line. So are you in a minute? And let me know.
Funny. It's Friday. You gotta go.
Are they still in there?
So.
All right, who's the party on Carlos Vasquez? Good morning. You'll need to type up your order.
Want me to type that up?
Yes, what's great too, because it's a lot of different things that
I
are.
understand, Judge.
All right, no
We
problem.
came to agreement last week, and Judge Angelini wouldn't believe my phone with the no contact order still in place.
Okay, all right.
Can I bring this in without him on Monday, Your Honor?
Yes.
Okay. He is here. You marked an FTA because he's in court 6 this morning.
Okay. All right, well, let me see him.
Carlos. Whisper.
All right, Mr. Vasquez. You're gonna remain on GPS, but you will be allowed to work.
Okay,
So if you're not at work, you need to be at home, you understand?
yes, ma'am.
And if there's some issue, or if you've been on GPS for a certain amount of time, everyone please whisper. So the way it works is GPS, the only exception for you to be outside your home is because you're at work. So if for some reason your work is the graveyard shift, then you can be there for that. You understand?
Yes, ma'am.
So your attorney is going to bring the motion back to me. Yes. And then what will happen is I'll sign it and he'll get a copy of that order. But starting today, if you have employment, you can go to work. Just make sure you still call GPS and let them know what your work schedule hours are, because you still need to call them.
Your Honor, the only problem with work schedule hours is Mr. Vasquez drives a tow truck. So the work can be at any time. You just need to call them, get the call in at night.
Yes,
Thank you, Your Honor.
just call them, okay? And make sure you do it. And if for some reason you can't get in touch with your pretrial service officer, just leave a message.
Okay, not a problem.
And Your Honor, just for your information, he's been on GPS for more than 90 days. There's been no indictment. We're not asking for anything out of the ordinary, just that he'd be able to work in this period of time.
Okay,
And at 180 days, I'll bring up something else.
all right, okay, thank you.
Your Honor.
Yes,
I will see you on Monday morning. To see what Your Honor.
yes,
Okay, thank you.
or sooner, if you want to bring it back this
I can
afternoon.
try to get it back this afternoon, Judge, but I got other courts.
All right,
You know
no
that.
problem, I do.
Confused.
Yeah.
Who's here on Gracie Segunda?
It's Grace, you know, Mark.
All right, so what is happening on this case?
Your Honor, we subpoenaed medical records from the victim. It's an SBI case, so we're gonna probably need those. We only have about 2 pages in discovery right now, so there's gonna be a lot more extensive records.
All right, what is the timeline you think on having those records?
I don't know. I got my investigator on it earlier this week, so I would assume at least another week, maybe 2 weeks. I'm not sure how responsive this hospital is.
All right. All right, Norma, on Gracie Segunda, can I have a 30-day reset, please?
They can come back on March 9th.
All right, we'll be back on March 9th and you'll need to be in the courtroom.
And Judge, I think we'll have the same announcement for Mario, is Mario Pineda? They're co-defendants for this case.
All right, we'll see you back then. And you both need to be in court. Do you understand? All right, I'm sorry, if you could unmute.
Oh, yes,
We understand.
we got it.
All right,
Thank
I'll see you back on March 9th then.
Okay.
Judge.
You're welcome.
Thank you, Jason.
And you're excused. Who's here on Richard Anthony Thomas? Mr. Thomas, come forward. Yes. All right, Ms. Ferguson, on Mr. Thomas, I need a jury trial date.
Just for the course awareness, I have a vacation letter, March the 9th to the 17th.
And I need an acknowledgement of discovery filed.
Okay.
And Mr. Thomas, your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you'll have to plea open to the court. Do you understand?
Yes, ma'am.
And how long do y'all expect this trial to last?
3 days perhaps.
I think about 3 days.
You know, my question is. Any videos?
I actually, I'm not sure. I think there's one, but I don't know if we probably won't.
It's not 13 hours.
No, it's
Okay.
nothing like
All right,
that.
that's the standard.
You, March 28th.
All right, your jury trial date is gonna be March 28th at 9 a.m. So we'll see you then.
Thank you, Your Honor.
And Ms. Ferguson will give you a reset form. All right, could I see the parties on Charles Garley?
Morning, Howard.
Good morning. Sorry, you're on this side.
You're on the left side.
Good morning, Your Honor.
I need everyone to please lower your voices. We're gonna go on the record. Court is calling 2021 CR 7282 State of Texas versus Charles Raynard Garley. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
For the
Mario
defense?
I'm sorry, Your Honor. Mario Moreno for the defendant.
And are you Mr. Garley?
Yes, ma'am.
All right, we are here because there was a discovery issue. And it was in regards to some records from internal affairs. So the court did receive those records on January 10th. We were supposed to be back on January 30th, but there was problems with my flight. So the court has had an opportunity to review the documents that were turned over by the city attorney, Mr. Cobb. And after reviewing those documents, the court is finding that the defense is entitled to the documents that are being presented.
Yeah.
What I can tell you is a majority of the IA file consisted of documents that defense should already have. It was the police reports, it was the body camera, and I'm assuming state you turned over the body camera of the incident.
Yes, Judge.
So it was the body camera. A majority of that is what it was. So I've given you the printed version of what's in there.
Thank you, Your Honor.
All right, so where are we on this case with regards to trial?
Judge, I think both sides just need to take a look just to compare what we have. It sounds like a lot of it matches up. I think we both just need a little bit of time just to make sure what's different and what's not.
Okay,
I agree, Your Honor.
Just maybe a week or two just for us to say, well, just to confer again.
okay. All right, Ms. Ferguson. On Mr. Garley, can you recall this for next week, please?
I'm sorry,
Garley, next week's setting.
Setting for next week.
Yes.
We can come back on the 7th.
All right, so we'll be back on February 7th.
Yes, ma'am.
All right, if there's nothing else, Ms. Ferguson will give you a reset form.
Thank you, Your Honor.
You're
Thank you,
welcome. Who is here on Clifford LeBlanc?
Morning, Your Honor.
So everyone, I try to keep the middle of the court as least congested as possible. Defense attorneys, if you'll put your file down on the state's table, they will call you in the order of appearance. They're not going to let anybody leapfrog over you. And as I say that, nobody moves. Why is nobody
Clear
moving?
the area. Thank you.
All right, court is calling 2021 CR 6041, State of Texas versus Clifford Henry LeBlanc. Could I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense.
Isidro Montoya, Your Honor.
And are
We
you-
are on the record.
Clifford LeBlanc.
Yes, ma'am.
I'm showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Clifford Henry LeBlanc who was placed on community supervision in 2021 CR 6041 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on February 23rd, 2022 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 5 in Bexar County, Texas. The defendant, Clifford Henry LeBlanc, who then and there failed to report to the supervision officer as to record for the month of August 2022 in violation of condition number 5.
How do you plead to that? True or not true?
True.
Your Honor, state waived all the violations.
Any objection to the state's waivers?
No, Your Honor.
All right, Mr. LeBlanc, did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, sentence you up to 3 years in prison? and up to a $500 fine. Did you understand?
Yes, ma'am.
There's no talking in the box while we're on the record, Mr. Leal. Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there an agreement?
Judge, there is, it's safety followed by applicant.
Is that the agreement, defense?
Yes, Your Honor, that is our agreement.
Mr. LeBlanc, are you asking the court to follow that agreement?
Yes, ma'am.
Right. What's your drug of choice?
Heroin.
All right, what I'm going to do is I'll refer him, I'll deny the motion, alternate and main conditions. We'll do a referral to felony drug court first. Do you have any, let me have you raise your right hand for me. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, can you state your name?
Trooper LeBlanc.
Mr. Leal, there's to be no talking in the box while we're on the record. All right, you can lower your hand. Do you have any violent history in your past?
No, ma'am.
All right. And do you have any other criminal history other than this drug case?
Yes, ma'am.
And what is that criminal history?
Bringing drugs or alcohol or phone into the facility.
Okay. All right. So what we'll do is I'll alternate main conditions to include a referral to felony drug court. And also we'll do safety. And see if felony drug court has room for him. If they don't have room for him, then we'll do safety first, then felony drug court.
So, Your Honor, just so that I'm very clear, felony drug court, check to see about the room.
Yes,
And then if not, safety followed by felony drug court.
yes, and he's to remain in custody until accepted.
I want to also make the court aware that that was the court's original condition for him to do felony drug court after he finished status. However, that's when Mr. LeBlanc absconded.
Okay. All right, so he's going to remain in custody.
Yes, Your Honor.
And Mr. LeBlanc, it's up to you whether or not you want help with your drug problem or not. If you continue on this vein, what's going to end up happening is you're going to end up going to prison, potentially. And then when you get out of prison, you may continue to use and you may not survive. You understand?
Yes, ma'am.
All right, so we're going to send you to felony drug court. If they can't accept you first, then you're going to go to safety, then you're going to go to felony drug court. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you. Thank you. May we be excused?
Yes.
Thank you.
Lisa Quintanilla.
Good morning, Your Honor. Good to see you on this, said be nice Friday.
It is. I see you here and I see you there.
Ah,
All right, court is going to call 2012 CR 5374, State of Texas versus Lisa Jean Quintanilla. Can I have parties announced for the record for the state,
Debbie Cruz on behalf of the state, Your Honor.
for the defense?
Joey George for the defense.
And are you Miss Quintanilla?
I am.
Showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
I did.
Are you the same Lisa Quintanilla who was placed on community supervision in 2012 CR 5374 for the offense of theft 20,000 to 100,000 on January 7, 2013 for a term of 10 years?
So,
All right, state.
Your Honor, I believe that the defendant had an announced temporary request from the court. Your Honor.
Yes.
The parties were here before, and at this point, the starting balance was 55,000.
Yes.
She's paid 20 towards that, so there's a substantial amount, 35,000 owing. They would like, what we propose is her son has agreed to sell his house to make the payment. He's put it on the market. It just hasn't sold because, well, you know what the housing market's been like, but apparently it's picking up again. I don't know that I think the goal is to make the victim here whole.
Yes.
And I think we could accomplish that if we just let them, give them a little more time to sell that house.
All right, so it depends. Are you requesting a continuance for this?
I would request continuance to see if we can't pay that balance off, Judge.
All right, any objection to the defense's oral motion for a continuance?
No objection, Your Honor.
All right, how much time are you requesting?
Sell a house to get it all done, it's realistically 60 days.
All right,
Unless you want to come, have us come back earlier on status, we can do that, whatever the court desires.
all right, so we'll reset this for 45 days for a status update.
Perfect, Judge.
All right, Ms. Ferguson, can I have a 45-day reset on Lisa Jean Quintanilla?
Yes, ma'am. You can come back on March 23rd.
All right, they'll give you a reset form for March 23rd.
Thank you.
Have a great weekend.
Thank you, always good seeing you.
Thank you.
Oh, yes. Well, we're just, so. Okay, yes.
Who's here on Ken Brown?
Ryan.
And where is Mr. Brown?
Mr. Brown is in federal custody still. The state's gonna work on it. I had been working with the previous first chair and he's not here, but I've talked to Jason. We talked about got him up to speed and they're gonna be working on it.
I already sent off the email, Judge, to sort of try to find out what's going on. The cases here aren't going to be associated with the actual bad cases of the robbery or assault. So I'm just sending off the email to find out exactly who I need to contact with the feds to see what the custody situation over there is.
And so how much time are you requesting?
Just a regular reset, Your Honor.
All right, Ms. Ferguson, I need a 30-day reset on Ken Brown, please.
So yeah, I'll try to get them.
Judge, we can come back on March 9th.
All right, we'll be back on March 9th.
Thank you, Judge.
Thank you.
Lisa Quintanilla.
They're in the hallway if you want to call. Yes. Joy Contreras is just in the hallway. Thank you.
Shorter. 2 weeks, or 2 days. I thought about taking my time.
Okay. All right, who's here on Jamarie Simmons?
I'm here, Your Honor.
All right.
Mr. Simmons is in the wheelchair in the gallery room.
So, Mr. Simmons, you want to come up, please? All right, so no gum chewing report. So my understanding is that in each of these cases, all the discovery has been tendered.
That's my understanding. I know Mr. Brawback filed a request for witness list, which we can provide.
Filed that last night.
Okay. All right, I need an acknowledgement of discovery on the assault case.
Okay.
I do have an acknowledgement of discovery on the possession case. So which case is going to be controlling for the state?
Your Honor, I'm not entirely sure. I am gravitating towards our assault case because our victim is cooperative. I don't personally know the merits of the drug case. But I didn't indicate to Mr. Brawback that I would try to get him an affirmative answer as to.
All right, has an offer been tendered?
Yes.
Yes.
And that's in each case?
Yes, it was.
It was global, Your Honor.
Yeah.
All right, Ms. Ferguson. I need a 2-week reset on Mr. Simmons. That's going to be your plea deadline date. On that date, you need to let the court know whether or not you're accepting the offer. If you choose not to accept the offer, then what will end up happening is the court will not accept any plea bargain agreements with a good cause. Otherwise, you have to enter a plea open to the court. Do you understand?
Yes, ma'am.
I'm sorry?
Yes, ma'am.
All right, Ms. Ferguson.
Judge, she's out in the hallway right now.
All right, let me give you a date.
Judge, we can come back on the 13th. Oh, I'm sorry, on the 16th.
All right, so we'll be back on the 16th.
Is that the plea deadline date? Your Honor?
Yes. And just get a reset form for Ms. Ferguson. And the person who is on the assault case, if you could please not leave until you sign the acknowledgement of discovery.
Yes, ma'am.
Thank you.
Thank you. Okay.
And Norma, February 16th, that's their free deadline date. Oh, yeah. Roger Neek Jones.
Your Honor, present on her case. She's in Collins County, and I'm not sure why.
And so you verified that she's in Karnes County?
She's been calling me, leaving messages.
All right.
And I've asked the state to run the TCIC and CIC so I can get it up for an updated one.
All right. Give me 1 minute. You have no idea what the case is, and
I don't, I actually Googled her name and I found she in a federal case, but I talked to that federal public defender and he said it was, she had got time served and she was on supervised release. So I'm really not sure. I think Karnes County is commonly a federal detention facility as well. But I don't know.
all right, who were you conferring with on this with the state?
Your newer prosecutor.
Oh,
Or in Jason.
all right. So she's saying that her client is in Karnes County and she's conferred with the federal prosecutor. So what do you see happening with this possession less than a gram case?
Prosecuted the full extent of the law, Your Honor.
So how much time do you need to see what's?
She mentioned, mentioned that to the earlier Karnes City or Karnes County rather. Judge, I mean, we just need probably just a couple weeks just to find out what's going on. I don't know what kind of charges he has down there, but I can get with my investigator to find out. And then we'll see if we can just resolve our case and let them take them down there.
All right.
Since he's down there already.
And so she's saying that maybe they got time served and they're now on supervised release. Oh, okay.
That's a possibility. That's what I talked to the federal public defender, but she wouldn't be in custody still on that. That's what it sounds like. So I'm not sure what's going on.
So Ms. Ferguson, can I have a 3-week reset on Roger Jones? Is that enough time?
That's plenty of time.
The 28th of February.
All right, so we'll be back on February 28th.
Thanks, Judge.
And then
You're welcome.
Okay.
Hi, just have a seat. I go in order of appearance. So once they put your file up here, we'll go.
Yes, sure.
All right, thank you.
Second row. Lady next to her, hey, again, the lady next to her, she's still talking, the one of the inmates socks.
All right, who is here on Leonardo Rosales?
Judge, how are you?
Oh, good morning. It's a great day. It's Friday.
It is a great day. It's not further anymore.
All right, and so you're on that side, counsel.
And the interpreter has.
All right, is there someone for the state on Mr. Leonardo Rosales? And we're not on the record. Oh, we're not on the record. Okay. So the court has all of the discovery. The court has the discovery acknowledgement.
Correct, yeah.
And I'm assuming you received a plea offer.
We have.
All right, and I show in my file that that plea offer was tendered on January 30th.
Correct.
And are you requesting a jury trial?
Yes, Your Honor, we have.
All right, Ms. Ferguson, I need a jury trial on Mr. Rosales, please. How long do you expect the trial to last?
2-3 days.
Mr. Rosales, your plea deadline date has expired. What that means is the court will not accept any plea bargaining agreements in this case without good cause. Otherwise, you have to plea open to the court. All right, your jury trial is going to be March 28th. They'll give you a reset form to sign. And counsel, the last time on November 17th, you said that there was no need for an immigration attorney, correct?
Yes, Your Honor, I will provide that assistance.
All right, thank you. She'll give you a reset form, then you're excused.
Your Honor. Okay, we're back.
Your Honor, may I be excused?
Yes, thank you. Thank you so much for coming. Have a great day.
Likewise, Your Honor.
Thank you. Who's here on Christopher Armstrong? All right, Mr. Armstrong, if you come forward. All right, as soon as he comes back in, we'll take this matter up.
Judge, I think he's in a pub.
People want an engraved invitation. Court is calling 2022 CR 11229, State of Texas versus Christopher Armstrong. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Alberto Rodriguez from the Strong.
And are you Christopher Armstrong?
Yes, Your Honor.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Armstrong, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
You waive it, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Armstrong, I'm showing you what's entitled court admonishment. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with unauthorized use of a vehicle? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Armstrong, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain agreement. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, there's a $1,000 fine. State recommends deferred adjudication. There's restitution of $600 to Apollonia Albzio, ALBZIO. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counselor, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be 100 hours of community service restitution and no contact with Apollonia
Albizo.
Albizo.
Yes, Your
Did you
Honor.
understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Into the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Your Honor, state offers state exhibit 1 and all attachments.
No objections, Your Honor.
Mr. Armstrong, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding the guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor. Yes, Your Honor.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. Spoke with Mr. Armstrong. Armstrong, he accepted responsibility. He's remorseful, and we're asking that the court follow the recommendation from the state.
All right, how old are you?
38.
Do you have any children?
Yes, Your Honor.
What are their ages?
My oldest is 18, and he goes 16 and 14.
All right, I'm gonna need you to speak up, okay? And everyone, could you please whisper? Are you employed?
Yes, Your Honor.
What do you do?
I run a moving company.
I'm sorry, what?
I run a moving company.
When you say you run a moving company, what do you mean?
I own a moving company. I help people move out of their homes into storages, pack for them, transport their goods to one spot to another,
And what? What are you transporting?
transporting furniture.
No, I mean, how are you transporting the furniture?
In a truck, in a box truck.
All right, so why are you still in this vehicle?
I wasn't on.
No, here's the thing. Let's be honest with me, right? Because I'm trying to figure out what's the best conditions for you.
Sure.
Now, this vehicle, you had a screwdriver in your pocket. It shows that the locks were punched out. Nobody is buying a vehicle from somebody with the locks punched out and there's no key to the ignition.
Yes, Your Honor.
So you're driving around a vehicle with a screwdriver in the ignition. So again, my question is, you're saying that you run a moving company. So I'm trying to figure out why you're still in the vehicle.
Yeah, I was in the wrong spot at the wrong time.
No, nobody's in the wrong spot at the wrong time unless I'm eating at McDonald's and somebody comes in and shoot up the place. But even then, I'm not in the wrong spot at the wrong time. Somebody came in and committed a crime. So driving a stolen vehicle is not, I'm in the wrong spot at the wrong time. You're driving a stolen vehicle. Maybe the vehicle was in the wrong spot for you to take it.
Yes, Your Honor.
So why are you stealing cars?
I was at the motel room. My dad just died. I was at the motel room. I wasn't working for the first 3 weeks of being there, and rent was due. My neighbor came and said, "Hey, I'm moving. You want to move this vehicle?" And I moved one of his vehicles for him. And
So you moved one of the vehicles with the screwdriver.
no, the screwdriver was on the floor. He started the vehicle.
So you're a 38-year-old, not a babe in the woods. And somebody tells you to move a vehicle.
Well, I ran the VIN number. Because I saw the ignition like that. I ran the VIN number. The VIN number came up clean, so that's why I moved it.
All right, your story is not believable. I don't believe your story, but
Sure.
the agreement is for you to have deferred. If you're drug tested today, what are the results going to be?
How do you think?
All right, you're going to get drug tested today.
Yes, Your Honor.
All right, 2 years deferred adjudication. Where are your children staying?
Right now, one stays here in Schertz, Texas, and the other two stay out in Matagorda County and Sargent, Texas.
All right, so you're not taking care of them.
Yes, Your Honor. I tell you, well, we're my two youngest are with their mom. Yes.
All right, are you paying child support?
Yes, Your Honor. I am free.
How?
Through the state.
All right, so that means that you were not paying child support and they decided to go through the state to get their money. When this is something that people don't understand, when you're on probation, part of your conditions of probation is to support your dependents. So if you do not support them, a motion to revoke is going to be filed under this court. You understand?
Yes, Your Honor.
All right, 2 years deferred adjudication, $1,000 fine that will be probated. Proof of employment within 30 days. There should be no employment as a home health care provider with minors. And probation, he says he owns a moving company. Can somebody make sure the truck that he's using has not been stolen? Just tell him to check to see if he's driving it with a screwdriver. There's to be restitution of $600 and no contact with Apollonia, APOLONIO. Abzio. 100 hours of community service restitution, 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. I'm gonna want parenting classes with triple P. Once that's completed, the remaining of the community service hours be waived. There's to be regular reporting by Zoom or in person. Regular UAs and field visits one time per month. And you're gonna do a UA today.
Yes, Your Honor.
Probation, is there anything else he needs? And probation, if you all want to count that field visit as his reporting, you can. Is there anything else you need from the court to be successful in this probation?
No, Your Honor.
All right, I'm gonna show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, good luck to you. Do better and make your children proud, okay?
Yes, Your Honor.
Probation over conditions with you.
You have me excused, Your Honor?
Yes, thank you so much. All right, who's here on Hillary Stillman?
I am, Your Honor.
Hillary Stillman.
Yes, he's in custody, Judge. It's an MTR based on a new number 1. It's a pending case out of County Court 12. I've spoken with Mr. Garahan about
So
that.
where's your client?
He's in custody.
All right, did you ask for him to be brought out?
Judge, I didn't. This is I did not ask for him to be brought out.
You can ask for him to be brought out. I like defendants to know what's going on with their cases.
Certainly, Judge.
All right, thank you. Just have him brought out and I'll take you out. Yes.
Do you want it done?
Are you able to do it here? Yes. Robert Reyna.
I'm present on that case, Robert. He's also sending this one.
All right, what's happening with this case?
We are requesting a reset. I've just become aware that Mr. Reyna has a medical condition and he needs to get me proof of that information. As
Okay, so
mitigation.
how does that affect this case?
It'll be mitigation.
I wasn't the one who conferred, Judge, but.
Who did you confer with?
Sorry.
Sorry, what? Oh, Judge, we have a
A medical condition from the defense, so I think we just like a short recess for them to provide that documentation to us.
All right, when is that documentation going to be provided?
How long do you think it'll take? A couple weeks?
Yeah.
Maybe a couple weeks, Sean, or 2 weeks?
So you're saying a couple weeks. I mean, can't you just go to your doctor and get it?
Yeah.
All right, so can you do that in a week? All right, so Ms. Ferguson, I need a 1 week reset on Robert Reyna.
February 9th.
All right, we'll see you back on February 9th. Ms. Ferguson will give you a reset form.
Thank you, Your Honor.
You're welcome. And I'll extend his plea deadline date to February 9th.
Thank you.
Hi. Thank you very much. And you have dated everything. Mom appreciates it.
No bar, no. I can see you.
You missed the bar number.
I missed the what?
The bar number, but I know you'll put it
Okay,
on.
got it, okay.
Anita Herrera,
There's John President.
hi, where is she?
She's in custody and she's pending a psych evaluation.
All right, is this Miss Herrera?
And so we were requesting a reset so that the psych evaluation can be complete.
All right, Norma, do you have an update on where we are in the psych evaluation? Has it already been filed? Has someone come to see you?
Yeah.
When did they come see you?
2 weeks ago.
2 weeks ago? All right, she said she's been seen by a doctor 2 weeks ago.
Yes, they're just waiting for the report from Dr. Connor.
All right, when do you want to recall this? Okay,
I can do, we can come back on March 23rd.
all right,
March 23rd.
March 23rd. And if you get it sooner and you want it on the docket sooner, just let us know. So if we get the report back sooner, your attorney will let us know because she'll get the report before I do. And she'll put you on the docket sooner. But for now, it's going to be February 23rd.
February?
I'm sorry, March 23rd. See, I was testing you. All right, do you have any questions about anything? All right, they're going to take you back, okay? All right, thank you.
Thank you, Judge.
You're welcome.
Oh, you want.
Is there a place I can do this?
Or.
I mean-
I'll give you.
Sorry.
Next time.
Just.
Who's here on Andres Diaz? All right, I'm sorry, you're on this side.
Yes.
So who's the prosecutor on this case?
Mr. Garaham, Judge.
So where are we on this case?
We've confirmed, we've reached out, we believe a conditional situation. We have asked the court, I'm saying that complete deadline, we're asking for one last reset to see if we can get this resolved. And I believe realistically it will be.
And Judge, that's correct. I mean, this is the first time I've seen the case, but talked to Mr. LaHood on it. And maybe it resolved possibly by dismissal, Judge, if we do have this opportunity, probably at least a couple weeks or so to do that. If not, then it would probably be set for an actual trial. And that's where we're at.
All right, Ms. Ferguson, I need a 3-week reset on Mr. Diaz.
February 28th.
All right, we'll be back on February 28th. That will be your final plea deadline date. After that, if there's no agreement reached, you're going to be put to trial quickly. You understand?
Yes, Your Honor.
All right, Ms. Ferguson, we'll give you a reset form.
Thank you so much,
You're
Judge.
welcome. Have a
great
good one.
weekend.
You too.
Yeah. 2 out of 2. 2 out of 2 and. Yeah, it's really. Okay, yes. Sounds good. I'll give you a minute.
Who's here on Jasmine Shaw? Jasmine Shaw. Where's the attorney on Jasmine Shaw? All right, Hillary Stillman.
Your Honor.
All right, thank you. Oh, this is a quick turnaround.
Yeah, I'm trying to do it quickly.
And we're finished with. Jesus Espinoza Lorenzo. The attorney for Jesus Espinoza Lorenzo.
Yes, ma'am. I'm here.
All right, come down. All right, counsel, have you had a chance to confer with the state?
Oh, yes, ma'am.
So where are we on this case?
Well, yeah, Mr. Espinosa has an immigration hold. But it says that he has political asylum because he's a Cuban and cannot be deported. So I'm asking for a brief hearing, just like 3 weeks, so I can investigate the case further. I know exactly what the situation is, immigration.
All right. Do you have an immigration hold?
Oh, yeah, no, he speaks only Spanish, I'm sorry.
All right, could I have an interpreter brought down? Just have a seat. We'll have the interpreter come in.
Thank you.
I just read it because like.
Yeah. One back. All the way back. And Judge, we're ready on Mr. Steele, but he's been brought out.
Okay. All right, Hillary Stillman. All right, what's happening on this case?
Judge, this is an MTR. It's based on a new number one, that's got it's out of County Court 12. I'm not the attorney of record on that case, but I need access to that footage. Mr. Garahan has told me to reach out to 12 so we couldn't get a hold of that footage so that I can download it and review it with my client. I'm asking this court for a little time to get that.
Okay, so when is this going to be incorporated?
Well, I hope I'll get 12 today, but I don't know when I'm gonna get the footage.
And Judge, I just checked the Verific system. It's a via bus a video that has not been uploaded or been sent over yet on that new case. And it's part of the new number one that's been violated on the NTR. So I asked the defense counsel to go to 12, talk to the prosecutors, tell them I asked for that to be done. That is usually the quickest way for it to get done.
All right. So, Mr. Stillman, I see you shaking your head.
Yes, ma'am.
This is what I have before me. I have a motion to revoke. These are the allegations in the motion to revoke. I don't accept any of them as true because I haven't received any evidence. But what I can tell you, if the state intends to go forward on this and you intend to plead not true, it's going to be a contested hearing. And it's better that your attorney has whatever the state is planning to present other than being surprised by it.
Well, that's fine.
So we're gonna get a reset so that your attorney can get this information. He's not the attorney on the misdemeanor case, so that's why he does not have the information for that. Okay? All right, so how much time do y'all think this will take?
Judge, due to the case being revenue and just previous knowledge of via, I think at least 3 weeks, Judge, to get that.
All right, so this is what I'm gonna do. I'm gonna reset this for 30 days. If you have the information before 30 days, if he gets it next week and he wants to come back, he can.
It's been almost 3 months and this is bogus to begin with, ma'am.
Yeah.
I'm sorry for speaking out, but that's the way it is.
I mean, you can, but here's the thing. Your attorney needs this information to go forward.
Yes, ma'am.
That's where we are. So Ms. Ferguson, can I have a 30-day reset?
You can do March 14th, Judge.
All right, so we'll come back on March 14th, and there's also an allegation on here of drinking alcohol.
That's.
So there we are. So we'll be back on March
14th, the Ides of March. Yes, Your Honor. I'll be here earlier if I get that information.
But you know what? People disregard the Ides of March. In the plays, the guy kept saying the Ides of March are upon us, and people just ignored it.
Judge, I'm sorry, not March 14th. We come back on March the 9th.
March
All right,
9th.
March 9th.
Yeah, sorry.
Well, the Ides of
That's
March
still-
are not upon
That's
us.
still the Ides.
Yeah. All right. We'll see you back then.
Thank you, Your Honor.
You're welcome.
And yeah, I'll talk to you soon.
Thank
Good morning. Can you put the Katrina Mendoza case up there? She's not. I've been asking. Sorry, they could get her.
All right, Jasmine Shaw is the attorney here for Jasmine Shaw. It's a fraud game. You brighten the Friday.
Oh, thank you too.
Oh, sure. You're welcome. Oh, yeah, it's good to be back. Yes, welcome.
Thank you. Thank you.
What's your name? Welcome. Come down anytime.
Thank you. Appreciate that.
And this one is not going to be on the record. This is just for me to give them information. I think they want to reset. Okay. But I always call down an interpreter because I want to make sure they understand what's going on. Thank you. Oh, you're so awesome. Thank you. All right, could I have Jesus Espinoza Lorenzo, please? Come down. And we're not on the record. All right. You are Jesus Espinoza Lorenzo?
Yes.
All right, counsel, what's happening in this case?
Your Honor, he has been indicted on the case, which appears to be a very simple case.
Could everyone please whisper?
But he insists that he has political asylum, that he was supposed to go before a hearing judge right before he was arrested in October. I need to investigate this case to find out what the situation is. He has an immigration hold. He says he is from Cuba and cannot be deported.
All right, does he need an immigration attorney appointed to him, counsel?
Would probably be a good idea, Your Honor.
All right, so Ms. Ferguson, I need an immigration attorney for Mr. Jesus Espinoza Lorenzo. Can you call and see? And then do you have all the discovery in this case?
Oh, yes, I got everything from the.
All right, did the state tender an offer?
Yes, they sent me everything.
No, did they give you an offer?
Oh, yes, ma'am, two offers, yeah.
All right, so just give me one moment. We're gonna see who your immigration attorney will be. All right. So are you enjoying the weather? You know what I always tell everybody, people complain in San Antonio when it's 100 degrees. So enjoy the cold weather.
That's exactly what I told someone this morning. It's so cold with it. And in June, we're gonna be complaining that it's too hot.
Yeah.
So we're never happy with what we
Yeah,
get.
but you know, I always say if we could get a balmy 72 degrees with a light breeze, that's the perfect weather.
And the notion.
Yes. Oh my gosh, that would be so great. I believe there's going to be an immigration attorney appointed from MAG, so we shall see. Managed Assigned Counsel. And Mr. Espinoza, this immigration attorney is not your immigration attorney for global matters. It's only your immigration attorney as it relates to this criminal case and the impact this criminal case would have on your immigration status.
There's any, someone down for the document.
So manager assigned counsel is sending an immigration attorney to speak to you today. And can I get a 30-day reset, Ms. Ferguson?
A 30 days.
Yes.
We can do March 7th.
All right, so we're going to come back on March 7th at 9 a.m. and your immigration attorney will come to speak to you today. And I'm assuming your immigration attorney will speak Spanish.
She's a Spanish speaker.
She's a Spanish speaker. Do you have any questions?
Yes. May I speak?
Yes, what's your question?
Él, porque yo veo que me habían puesto una felonía 3.
Perdón?
Me habían puesto una felonía 3, un cargo de felonía 3.
Well, I found out that they had put a third degree felony on me, but a third degree felony
Va a ir un arresto, pero que yo
of evading arrest, but
apenas llevaba aquí ese día en el país, llevaba casi un mes.
I had only been to that day, I
Just
had
one
only
second,
been
let
a
me-
month in the country.
All right, let me stop the interpreter and let me stop you just for a moment. It would not probably be wise for you to speak to me about the facts of this case. You need to speak to your attorney about that, and then your attorney may make the decision for you not to go into facts of your case.
Yeah, no, I have told him that he cannot speak about the case directly to you until we make a plea of some kind.
I mean, he can speak to me anytime he wants to, but your attorney is suggesting that you not speak about the facts of the case.
Okay.
All right, is there anything else you need to speak to me about?
Yo no sé nada de él.
No, that my father passed away and I don't know anything about that.
Okay, all right, you'll have to confer with your attorney over that. I'm sorry to hear about the passing of your father.
And I will speak to him at the jail tomorrow. I will try to arrange to speak to him tomorrow.
All right, so Mr. Alaman, you may want to remain. His immigration attorney is coming to the courtroom now.
Okay.
So the next time I'll see you will be March 7th, unless your attorney wants you brought back over sooner.
Okay.
All right, thank you. Thank you.
Pleasure, may I be excused, Your Honor?
Yes, you may be excused.
Do you think the immigration attorneys can stand it?
Yes, I was been informed they speak Spanish.
Thank you.
All right, thank you.
Thank
Good
you, Your
seeing
Honor.
you. Have a good one. Is the attorney here on Jasmine Shaw? Elsa Bacara?
Right here, Judge.
Good morning, Judge.
Good morning. All right, what's happening with this case?
Judge, we prefer, she's requesting the jury trial.
All right, how long is this trial gonna last?
Okay.
A day? Oh, all right, Ms. Ferguson. On this case, it's a one-day trial.
I mean, jury selection one day and 1 full day of evidence.
Okay. All right, what time, Ms. Ferguson, what date?
I can do February 28th.
All right, February 28th will be your jury trial. Do you have all the discovery?
Yes.
All right, I'll
we
need
have
an
all that.
acknowledgement of discovery.
I think we've done one, Judge. Is there not one fine?
No. Oh, you know what? You have,
This one's been said several times.
let me see. Ah, it's there. But I saw where Angelini granted a motion for continuance. And I'm assuming,
On this case? Yes, it was. That's back for last time.
okay, and so he had set a motion for continuance, so I thought maybe that was because there was additional discovery.
Not to.
No, I honestly don't know why, but I do remember talking about it.
Mike was very good at the beginning about ensuring discovery was in compliance from the state.
Oh, yeah, we've done, actually, we're looking for more discovery than exists. So
Okay. All right, this will may be my second trial with you, Mr.
I
Piper.
think it may be.
All right, so we'll come back on February 28th, just get a reset form from Ms. Ferguson for your jury trial.
We'll do, would you, I'll take care of it. You're down, please. Okay.
I'm still. I'm gonna put. I'm still on. Same joy.
All right, Jasmine is the attorney for Jasmine Shaw here. All right. Caroline, you can stop us back to the comment first. That one's done. Christopher Gibbons.
I'm here, I'm judge that, we're off docket. He's in custody. We entered a plea last week, a recommendation for probation on the drug case.
Yes.
He was referred for the drug court screening, which apparently been done already. So the court consider a PR bond. Talked to Jason this morning. He's not a lawyer.
All right, so why is he in custody?
Judge Angelini kept him in custody for his drug court about
His bond, got off his bond like back in October, I think. And he got picked up around Christmas. He was in custody.
All right, so has he pled to probation?
He played last week. There's a recommendation for 6 years probation, I think, and there was a referral for a drug court jury, which I talked to my client the other day. He said that John, he came to see him.
All right, so has he hasn't been sentenced yet?
No,
has
it
he?
was reset for PSI. Judge Angelini reset it for PSI.
All right, so are we able to bring this over on Monday and just take care of the sentencing at that time?
I don't have a problem. I'm fine with that, Judge.
All right, so if you'll talk to Ms. Ferguson and we'll have him brought over on Monday, and if you could check with probation and make sure that if felony drug court has accepted him, so I can give him instructions for felony drug court. Counsel, just give that to Ms. Ferguson or no. Jacob Garcia. All right, so what is happening with this case?
Your Honor, I think it just was another trial date.
All right, so do y'all have last time we were here in August, it was some DNA testing from underwear. Has that been completed?
It is completed.
All right, so do y'all have all the discovery?
Yes, Your Honor.
All right, so I need an acknowledgement of discovery file. Has an offer been tendered?
There has been several. We're still in talks right now. The ones that have been tendered, we've rejected.
Okay. All right, your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plea open for the court. How long do you think this case will take?
2 to 3 days.
All right, Ms. Ferguson, I need a reset for jury trial 2 to 3 days. Thanks for dressing appropriately for court.
Yes, ma'am.
I can use April 4th.
All right, we're going to come back on April 4th for your jury trial.
Yes, ma'am.
Ms. Ferguson will give you a reset form.
Thank you.
You're welcome. Who's here on Jordan Robbins?
Morning, Judge.
Good morning. Where are we on this case? You're all crowded up here. Why are there so many people in the well?
Oh.
No, I mean, you're fine. Like, is there something you want?
Yes, Your Honor, I believe I missed you calling my case. I stepped out to speak to another client, so I was just
Okay,
here.
is that Shaw?
Yes, Your Honor.
All right, just have a seat and we'll call you up. Can I have the file on Shaw?
So Judge, this case, there's a lot of discovery on it. There are basically all the electronics were seized and a search warrant was executed. I need to go through on our side of the discovery to make sure that we actually have all of those devices, which is taking a lot more time than I anticipated. And so I have not been able to do that to ensure that we have them and that we've reviewed them. So we're not turning over anything we can't turn over and then duplicating those for the defense attorney with the items that I can't.
All right. Ms. Ferguson, can I have a 30-day reset on Jordan Robbins for discovery? All right, we'll be back on March 7th to get an update.
Yes, ma'am. Thank you.
You're welcome. Ms. Ferguson will give you a reset form.
Yes, I'll come.
All right, who is here on Uriah Huffman?
Judge. Good morning.
Good morning. So where are we on these cases?
So, Judge, we are diligently moving forward. Talked to Garahan about trying to formulate an appropriate offer. Their complainant, I believe last time that contact was undergoing some medical procedures, so they haven't been able to have that discussion with him yet. So I think that's really got kind of the only holdup.
And where are we on October 17th? You said there was potentially some jurisdiction issue.
I think we've resolved that enough that I think the state can proceed forward.
And Judge, pretty accurate, Mr. Alexander said, I do have good contact with the victim. I believe I should be talking to the victim this morning at some point over the telephone. So I can give them an update on an offer at that time. I just, in light of these circumstances of the case, I'd like to talk to this victim before I make an offer.
All right, is 30 days enough time?
That'd be great, Judge. Thank you.
All right, Ms. Ferguson, can I have a 30-day reset on Mr. Huffman?
Oh, we can come back on the 21st.
All right, we'll be back on March 21st. And it states you're to make an offer on March 21st.
Yes, Your Honor. Thank you.
All right, you're excused.
Thank you, Judge.
Jasmine Shaw. All right. So her plea deadline date was actually January 31st, so it's extended today because of the weather. So what is happening on this case? Is she accepting the plea or not?
She is not accepting the plea, Your Honor, and we're asking to set it for trial.
All right, your plea deadline date has expired. The court will not consider any further plea bargain agreements in this case without good cause. Otherwise, you have the plea open to the court. Do you understand? Okay, here's my question. Why is it that people talk loud in the audience, but then when they come before me, they whisper? That's a question I have.
In other words, while the judge is talking, y'all need to be quiet.
Okay, so how long do you expect this trial?
2 days, Judge.
All right, Ms. Ferguson, I need a jury trial date on Jasmine Shaw, please.
March 7th.
All right, your jury trial date is going to be March 7th. Ms. Ferguson will give you a reset form, then you're excused.
All right, thank you, Your Honor.
Katrina Mendoza.
Here, Judge.
Oh, so in this case, the last time we were here, there was a supplemental report from Detective Pending. Has that been done?
Yes, Your Honor.
Then there was the vehicle search and cell phone search. Has that been done?
The cell phone search is still in process. It's a password protected phone, so they are, it's been hooked up to the machine trying to break the password. So that's the only thing holding that up.
All right, and then there's the statements from the hospital witness. Has that been done?
I don't,
That was part of the same exam. I think
Okay,
it wasn't complete.
So has that been?
the same exam is complete.
All
It
right,
has been done since the last time.
all right. So there's nothing else pending from the detective. The only thing that's outstanding is the cell phone?
Yes.
And whose cell phone allegedly is this?
We believe it to be the co-defendant, Jose Ruiz. However, it's not 100% clear until we can get into it.
All right, I'm gonna set this for 30 days. And then if it's not broken, it's not broken.
Okay.
All right, Ms. Ferguson, can I have a 30-day reset for discovery?
March 21st.
All right, we're gonna come back on March 21st. Is there anything else?
No, Judge.
All right, thank you. Roland Lopez. Who's the attorney on Roland Lopez? All right, Pete Castillo.
Good morning.
Good morning. So much happened with the football season. I mean, your Pittsburgh Steelers, my New Orleans Saints,
Yeah.
the Cowboys.
They played. And still kind of pretty good.
Yeah.
They're not, it was a down year for both.
All right, we're on the record. Court is calling. Excuse me, you all in the back of the box need to stop talking. Court is calling 2022 CR 11796, State of Texas versus Pete Castillo. Could I have parties announced for the record for the state?
Jason Garrett for the state, Your Honor.
Defense.
Roberto Ambrosino.
And are you Mr. Castillo? Counsel, you received all the discovery in this case, and did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Castillo, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
I did.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it and did you understand it?
Yes, ma'am.
All right, counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Castillo, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand that you're charged with burglary of a building? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine.
I do.
Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I do, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state will call the right to remain silent?
I do, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
yes, I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Castillo? Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargaining page, did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishments be assessed at 2 years in the state jail facility. There's a $2,000 fine, no application for deferred. State recommends community supervision. They will take in consideration 694-124 and 686-083 and restitution, if any, to advance auto parts. Did you understand that to be the plea?
Yes, Your Honor.
Defense,
Yes, Your Honor.
state?
It is, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both cases?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargaining agreement, the state is requesting that your community supervision be for a term of 2 years. There be a top evaluation, 200 hours of community service restitution, no contact with advanced auto parts and Tuscany Park apartments. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offer state exhibit number 1 with office attachment, Your Honor.
No objection.
All right, state, if you wish to take your seat to work on the other cases, you can.
Thank you, Judge.
You're welcome. All right, Mr. Castillo, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, it's my understanding that he has dependents that he needed to get out and support, so that's the court followed through work.
All right, Mr. Castillo, how old are you?
38,
How many children do you have?
1,
Age?
8 months.
And does that child live with you?
No.
When's the last time you were employed before you were arrested?
2 months prior to that.
Doing what?
Fast food,
Fast food where?
Jack in the Box, like a restaurant.
What were you doing in Jack in the Box?
So,
Cooking what?
quality burgers.
Everything?
Yes, ma'am.
All right. Usually at McDonald's, you either work the fries or you work burgers. They don't have you doing everything. So that's why I asked.
Yes, ma'am. The grill, fire,
Okay, why are you taking things from Advanced Auto Parts?
I was heavily under the influence of barbiturates,
So what drugs have you been using?
marijuana, alcohol, pills,
Marijuana,
alcohol,
and
and
rest.
barbiturates.
How often?
Daily.
I'm sorry?
I was using them daily.
Daily. What's your support system?
I have a brother, an older brother here, and a father who's in Dallas, Texas. My brother is supporting.
All right, and what's up with the tattoos on the face?
Just a ignorant mistake.
Well, here's the thing. You need to be honest with me, and let me just tell you why. I don't do cookie cutter probations. I know sometimes people have a set thing. This is what everybody gets. But I need to know more about you if you're asking me to grant you probation from the bench. So I'm trying to learn about you so that I can give you conditions where you'll be successful. Now, if there's some gang issue, guess what's going to end up happening? Probation's going to find out about it. You can tell me now, or probation can find out about it later, and then I'm going to get a report.
So the upside down process, Paul was crucified upside down.
I'm sorry, I can't hear you.
Paul was crucified upside down. People think it's demonic, but it's not. He wasn't worthy. He said he felt that he wasn't worthy enough to be crucified like Jesus, so he crucified himself upside down. They crucified him upside down.
So you felt a connection to Paul when you're doing that in honor of
Not
Paul?
necessarily, but I felt like he was a very interesting person. So
All right, and what are these, what's the star tattoo and these other tattoos about?
I'm from Dallas, Texas.
And
I
you need to start a
I like the
reminder of
Cowboys. I like Dallas Cowboys. So, yeah, I can understand how it could be people from team to find it game related, but that wasn't my first.
Well, the Cowboys have been having a disappointing season.
Yes, man.
You know what I always tell people about the Cowboys? When they had Tony Romo, I told them, Tony Romo by any other name is still Danny White. He's not gonna get you a championship. And it's the same thing that's happening now. That's still Danny White. He's not getting you a championship. I think your attorney, the Pittsburgh Steelers, will tell you the same. Am I? Yeah.
Yeah, I would.
All right, so this is what I'm gonna try to do. I'm gonna try to get you some help for your drug help. So this is what's gonna end up happening. I'm gonna grant you probation from the bench, but you're gonna remain in custody. Felony drug court will see him next week. And since it's too late for them to see him now, but he'll see them in custody. They'll probably see him by Tuesday because I don't want to send him out in the world on the weekend and he has this major drug problem. So they'll see him and if they can get him in probation, they usually do their own tap. So if you all are able to accept their tap evaluation, if they don't accept them, and if the request is for inpatient treatment from probation, we're going to start off with intensive outpatient treatment and see what he does. But I'm hoping felony drug court will accept him. And you need to be very honest with felony drug court. That's a good program. It's an intensive program, but it's for your best. Okay? All right, the court will sentence you to 2 years in the state jail facility, suspended and probated for 2 years. There's a $2,000 fine that will be probated. Take in consideration 694-124, 686-083. There's to be restitution and no contact with Advanced Auto Parts Counsel. If you discover that the restitution amount is something that you think is inappropriate, we can have a hearing on that. There's gonna be regular reporting by Zoom or in person. Felony drug court evaluation in custody. If not accepted, then intensive outpatient treatment with probation. 90 meetings in 90 days. I'm gonna want field visits one time per month, and probation, if you want that field visit to count for his reporting, that can be acceptable to the court. 200 hours community service restitution, 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. I'm gonna want parenting classes with triple P. Once you complete the parenting classes, the remaining of your hours will be waived. There's to be no unsupervised contact with minors. So if you want to see your 8-month-old, you'll need to have an adult present. You understand? That may change once you're in your sobriety. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Probation, is there anything else he needs?
Your Honor, did you say UAs?
Yes, we'll do the UA hotline until further notice, and I want him tested at least once a week.
Yes, Your Honor.
And I don't know if I said it or not, but there's to be no contact with Tuscany Apartments, Tuscany Park Apartments. All right, is there anything else you need from me in order to be successful? All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. You have a child, hopefully that child will be proud of you. The only way for that to happen is you're going to have to be clean and sober. Whenever you use drugs, it may be the last time you use because they're not FDA approved. So you're gonna have to do better, all right?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome. Good seeing you.
Good luck.
And as you go forth, be sure to accept the challenges from Dallas Cowboys fans. They're gonna tease you about
It's
the,
bad.
they're gonna tease you about the Steelers.
It's bad. Well, we both didn't get to the Super Bowl, right?
No, we did not.
So, hey, it's all the same.
All right.
Thank you. Have a good weekend.
All right, you too. Who's here on Caleb Coleman Lee? All right, have you conferred with the state over your request?
Yes, I have.
All right, is there an agreement?
On some of the issues, not all.
All right, we're gonna go on the record of 2022 CR 2393, State of Texas versus Caleb Coleman Lee. Could I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
All right, for the defense.
Regina Scrivener-Tibbs for Caleb Coleman Lee.
And are you Mr. Lee?
Yes, ma'am.
Thank you for dressing appropriately for court.
You're welcome.
All right, so I'm here, I guess we're here for the court to make rulings on your request for production. Is that correct?
That's correct.
All right, so the first thing we have a list of names and addresses of all prosecution witnesses, including rebuttal witnesses who are reasonably expected to testify at any stage of the trial.
No objection, Judge.
All right, that will be granted. Any statements or reports? The second one, any objections?
No objections, Judge. It's just that the state doesn't have any medical records in its care, custody, or control.
All right, so I'll note for the record that the state is saying that they do not have any statements or reports, including, let's backtrack a little bit. So they're saying any statements or reports. So statements or reports, the court is assuming that to mean witness statements. Is that correct or no? Counsel?
That's correct.
And so, Judge, there were witness statements that were taken. It was an interview that was recorded that has been provided to defense. I think that's where she mentions medical records, but she doesn't say here are the medical records. If that makes sense.
All right, so are there any medical records?
We don't know.
Judge, this is the issue that I have.
Basically, at the time that this incident occurred, which was in January 2021, she stated that she sustained an injury after the fact. There was a video when the cops first went into her home, she had no injuries. Later on, she came back and provided pictures where she had sustained injuries. And she said, and she told one of the prosecutors, she had 130 pages of medical records. We've been requesting those records for the last 6 months. Now, our issue is we want those medical records because we want to be able to see how she sustained those injuries.
Okay, so then here's the question the court has. Are there medical records in existence?
Yes, Judge, but the thing is that she didn't say that to a prosecutor. I believe she told that to one of the detectives. He told the detective, I have these medical records. The issue with contacting her is that she has current pending criminal charges, which she doesn't have a defense attorney for. So we can't contact her.
So her current criminal charges, where are these pending?
One of them is in County Court 12. I think it's a DWI. She's awaiting, I don't know if it's awaiting her first court date or what's happening, but when I checked, there is no defense attorney that's been appointed.
Okay, so when is that case expected? When is it on the docket?
I think it's for either February 10th or February 21st. I have to double check to make sure I get the date right.
All right, so this is what we're gonna do, because if there are medical records in existence, then she needs those medical records. I understand why the state can't contact her because she has a pending criminal case. So what we're gonna do is, can you check and see what date it is, and we will bring this back after her misdemeanor case to see if an attorney has been appointed. And then I will have her attorney come here and state, you all can talk to her attorney and see if the attorney has any objections to you all speaking to her.
One of the things that I would like to request, Judge, is if the state has any information where she received medical treatment, I would like that turned over to me because I could at least subpoena those records.
Okay.
And Judge, the only information that we have is in the interview, she tells the detective, I went to a medical facility. I can't remember what suburb, but she says a suburb here in Bear County.
Okay.
And that's all we have.
All right, so this is what we're gonna do. Counsel, if you can tell me when her misdemeanor case is set, and we'll call this case back 2 days after that misdemeanor case is set so that the state can let her defense attorney know, or you can have that deferred defense attorney's information. And we'll have her, if somebody wants to subpoena her, we'll have her come and she can come with her misdemeanor court attorney.
Fair enough.
And then, so I think it's best for us to continue your motion for discovery until another date, so that we can make sure that everybody's on the same page. So, Ms. Coleman, Mr. Coleman, I'm not expecting you to go to trial till your attorney has all the discovery that she's entitled to, okay?
Yes, Lord. Judge, in the meantime, my client has been on house arrest. He's on a monitor. He hasn't had any problems, any violations since he's been on probation. He's unable to work. He's unable to get employment.
Just one moment.
Judge, I got the date. She's awaiting arraignment. It's February 21st.
February 21st, okay. Ms. Ferguson? Can we have this case called back on February 21st? And Norma, and which court is that?
County Court 12, Judge.
All right, and what is the witness's name?
It's kind of a hard one.
Tia Coots.
Yeah, Tia Coots.
How do you spell the last name?
K-U-T-Z-A.
K-U-T-Z-A. And the first name?
Tia, like D-T-E-A.
T.
T-E-A.
All right.
T-E-A and last name K-U-T-Z-A.
All right, so Ms. Ferguson, and I'm sorry, it's out of county court number.
12. And Judge, also for information, I just did look, she does have an at-large case that was awaiting indictment. It's from 2019. I don't see any defense attorney appointed on that either.
All right, and where is that case out of?
It's an at-large case. Judge, it hasn't been assigned anything.
And what is the charge?
It is, I think it was a robbery. Burglary application, Judge. But filed at large. No court assignment.
All right, so Ms. Ferguson, we're gonna recall this case for February 21st. And could you put in the system that County Court 12 was the contact us? If this Tia Kutsa shows up. Now, her client wants to be able to work while he's on GPS. Any objection to that?
No, Your Honor.
All right, just give me, pull up the page and write on there that it's agreed that he's allowed to work. Okay. All right, Ms. Ferguson, we'll give you a reset form.
Thank you.
You're welcome. Sure.
Right. You have a proposal.
Is that Hunter?
Morning, Judge.
Good morning. All right, Mariah Rodriguez.
Your Honor, hi.
Hi.
Ms. Rodriguez is not here. She is in Dubuque County. She has been sentenced to 2 years probation for bail jumping and ordered into a program. She is in residency at Lifetime Recovery with a release date of September 13th, 2023.
All right, you want to talk to the state about this case as far as?
And I didn't know if there was any way, what I wanted to ask, is there any way we could Zoom or?
Yes.
I don't know.
Lifetime Recovery will allow Zoom.
Yes, yes, they said, so I just need to ask.
Yes.
Okay, thank you.
So when do you want to do the Zoom?
Well, I need to, because she has never appeared, I haven't got any
Okay,
offers.
all right.
Judge, may I approach with the B sheet? for
Yes.
Mr. Lee? Yeah.
Yes. All right, just let your client know that he'll still need to let pretrial services know that he's working. You're welcome.
You want to ask that?
Yes. Yes.
Exeter.
Well, the person he came with can go to the Vegas. We can all smile. I'll let him know. Mr. Armstrong? All right, my understanding is someone brought you here today? All right, and that there is a child that may be without care?
Babysitter, we don't have a babysitter right now.
All right, so she can leave and she can leave you bus fare, but I'm getting my UA today. You understand?
But I don't have, the problem is right before I came to see you, I was just by turning in the hallway and I used the restroom and I came in here.
That's okay.
So
We'll wait for you.
it's fine. I guess what it is.
Yes.
All right,
We'll wait for your UA.
it's fine.
It's not a problem with the court. Who's here on Abigail Morales?
Judge. It's my vehicle.
I'm sorry, what?
That is my vehicle.
Well, all I know is I'm not letting you leave until I get my UA.
I'm not gonna let her hold my vehicle.
Well, I mean, she can, you can give her money for the via bus. I don't know why people accompany adults to court when they're not on the docket. All right, the court is calling 2023 CR 0062, State of Texas versus Abigail Morales. Could I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense,
Robert Gallina.
are you Miss Morales?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Morales, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am. I did.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are. Your Honor.
Ms. Morales, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am. I did.
Did you understand your charge of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am. I did.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, I do.
Ms. Morales, has anyone threatened you, coerced you, or placed you in fear to get you into this plea? Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, punishments be assessed at 75 days in the Bexar County Jail under 12.44 of the Penal Code, and there are no applications. Did you understand that to be the plea?
Yes.
State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am. I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motion?
No motion, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. State exhibit number 1 with all this attachments.
No objection, Your Honor.
All right, state you may be seated to work on other cases. All right, Ms. Morales, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am. I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, laboratory reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachment, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, I believe the plea bargain was for to judgment satisfy it. I haven't verified the amount of days she's been in, but believe it's, that's part of our plea bargain.
All right, the court will sentence you to 75 days in the Bexar County Jail under 1244. The court will give you credit for any time served. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Do you have any children?
Yes, ma'am, I do.
What are their ages?
He's 8 years old.
All right, so here's the thing. There are plenty of places in San Antonio and in Bexar County where you can get drug treatment for free. Your child, I'm assuming, wants you to be around.
Mhm.
You want to be around for your child, and you want to be somebody your child can look up to, right?
Yes, ma'am.
So when you get out of jail, you need to find yourself a AA or NA meeting or some kind of facility to help you with your problem, because otherwise what's going to end up happening is you're going to be back here, maybe you may get a hold of some bad drugs and die.
Mhm.
And in which case your son will be talking about how his mom passed and he's going to have trauma from that.
Mhm.
And I don't think you want that, right?
Mhm.
So get your life together. All right, good luck to you.
Thank you.
You're welcome.
Oh, shit. Thank you.
All right, who's here? Roland Lopez. What's happening with this case?
Hi, Judge. So Mr. Lopez has been on probation for about 5 years. He's got 6 months left. They filed a bunch of technical violations on him.
Well, no, but I mean, what are we doing with it?
Judge, I think Angelini set us for a contested hearing on the 1st or the 31st.
Yep, so we're here for a contested hearing.
Yes, Judge. And obviously with the delay, it's been, I guess it's somewhat in the air.
Well, no, I mean, state, have you conferred with the state?
Yes, sir.
Are you all ready to proceed?
Yes, sir.
All right. So the court is calling 2018 CR 0165, State of Texas, you're on that side, counsel.
Oh, sorry.
State of Texas versus Roland C. Lopez. Could I have parties announced for the record for the state,
Jason Dorgans for the state.
for the defense?
Kurt Hopke for the defense.
All right, so on January 25th, the defendant entered pleas of not true to violation of conditions 2, 2, 2, 4, 5, 5, and 9A. Mr. Lopez, do you continue to wish to plead not true to those violations?
Yes, ma'am.
All right. And are you the same Ronald C. Lopez who was placed on community supervision in 2018 CR 0165 for the offense of possession of a controlled substance, penalty group 1, 1 gram to 4 grams on July 27, 2018 for a term of 4 years and extended for a total of 1 year? Is that you?
Yes, Judge. Roland.
Oh, Roland.
Roland, yes.
Thank you. Is that you, sir?
Yes, Judge.
All right, state.
There's the state calls it Sean Abrams.
All right, Ms. Abrams.
And Judge, I would object to this witness that she doesn't have any personal knowledge on.
All right, we'll find out. All right, Ms. Abrams. Could you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Bashan Abrams.
All right, state.
Ms. Abrams, what do you do for a living?
I'm the court liaison officer.
All right, I need everyone to please whisper.
I'm the court liaison officer for the 187th District Court, working for the Adult Probation Department.
What are your duties in that position?
I am the go-to person between the court and the probation department.
And you said that you are actually a probation officer with adult probation. Is that right?
That is correct.
Okay. So do you have access to the chronologicals and other notes made by probation officers who were supervising defendants?
Yes,
And in particular, do you have access through your employment to adult probation's records regarding this defendant, Roland Lopez?
yes.
And do you have access to those right now, or would you like a copy of them?
I would like the copy that you have.
Just for the record, I'm going to tender copies of chronologicals and other documentation that was provided to the defense at the prior setting for this case after your review. Could you just take a look at that and see if that reflects documentation related to Mr. Lopez?
Everything here appears to be from Mr. Lopez's file.
Okay. And have you received communication from Mr. Lopez's current probation officer in relation to this case?
Priscilla Sinceros, yes.
And in particular, did you receive information related to the violations that are alleged in this motion to revoke community supervision?
Objection calls for hearsay.
I'm sorry, could you repeat your question, please?
Did you receive communication related to the alleged violations in this motion to revoke community supervision?
All right, objection will be overruled.
Yes.
All right. Did you receive communication about November 17th of 2022?
Objection calls for hearsay.
All right, that'll be overruled.
I need to repeat the file.
May we have a minute, Your Honor?
Yes.
Session.
Yes.
All right. What was documented for November 17th?
Objection calls for hearsay.
All right, that will be sustained.
Your Honor, I think it's established that probation officers can testify to each other's notes and records.
You want to lay the foundation for
Sure.
that?
What was the nature of the documentation from November 17th, 2022? Who made that record?
The record was made by Priscilla Sinceros.
And I think you established that she is the current supervision officer of Mr. Lopez, right?
That is correct.
And did she make that record in the course of her duties as a community supervision and corrections department officer?
Yes.
And did it reflect activities that she engaged in as a part of her duties?
Yes.
All right. What did she describe happened on that?
Objection calls for hearsay, confrontation clause, Fourth Amendment, Sixth Amendment, and that this is just reading a document that was not submitted under a business record affidavit or anything like that. There's no exception for hearsay that is going to allow her to testify from communications from another person who's not in this court.
State.
Judge, I don't believe the confrontation clause applies in a hearing for a motion to revoke community supervision. And as I mentioned, the case law is established that probation officers can testify to each other's documentation in relation to their supervision of probationers.
Really?
All right. So, okay, I'm not going to allow sidebar comments.
I'm sorry, Judge.
All right. So with regards to the confrontation clause, yes, it does apply. But with regards to your establishment of it as a document kept in the regular course of employment, the court will allow the question to be asked.
Can you repeat the question, please?
This one, I don't even remember. What was the nature of the interaction that Priscilla documented on November 17th, 2022?
This was a virtual office visit conducted by Ms. Cisneros with Mr. Lopez, and it was done via Zoom. And
what happened during that interaction?
during the interaction,
Judge, I'm gonna have to do a running objection to this.
All right, so
Any communication by someone out of court being read to the court by probation, and she's also using something to refresh her recollection, but it's not even, it's just reading what the
All right,
document
so
says.
this is what the court has before it. In the allegations, it's either he fails to submit or he did not fail to submit. So if there's anything in the document that is not addressing those issues, the court is not going to allow testimony to that. So,
And we'll narrow the question. Was there any documentation related to the submission of a urinalysis sample around November 17th, 2022?
the Ms. Cisneros notes indicate that she directed the defendant to submit a UA on this date.
And was there any record that you submitted on November 17th or the next day, November 18th, 2022?
No,
Was there any indication that he provided proof of employment or otherwise documentation that he was gainfully employed on November 17th, 2022?
I would need to review the file to see if there was any employment in there. However, there are notes indicating that the defendant stated he was working 12-hour shifts and he could not submit due to him working the 12-hour shifts. He
So
indicated that he could not submit that date nor the following day because of the work schedule.
Your Honor, may the witness sit down briefly to review and see if there was any documentation submitted in the.
all right, if you all want to review the files and if you all want to confer, you're more than welcome to confer. All right, just have a seat. And counsel, have you seen the probation's file?
I have a copy of the chronological section.
Okay. That's what's up next. Yeah. Christopher Davis. Christopher Davis, come on down.
Let's not be up here, Judge. It's in custody. No, it's not. It's really just strictly administrative.
All right, so here's the thing, everybody. I always ask for you all to have defendants who are in custody come out so they'll know what's going on with their case. All right, so they will bring your client out and we'll take up the matter. Stephen Miles. And where's Mr. Miles? All right, Mr. Miles, come down. All right, so do you have all the discovery in this case?
We don't need any more, Judge. I think we're fine. We were in impact court set and we got rotated back up here. So we're ready to go.
All right, State, can you make sure that an acknowledgement of discovery is done, please?
Yes, Judge.
And how long are you all anticipating this trial?
It's not very long, Judge. Maybe a day and a half.
All right, Ms. Ferguson, I need a jury trial date for Mr. Miles.
I can do April 11th. Sure.
All right, your jury trial date is going to be April 11th. They'll bring you over dressed for trial. You'll be brought over dressed in whatever clothing you have at the jail. If you wish to appear in something else, you need to make a clothing exchange with your attorney. If you do not sign that clothing exchange, it will not happen. Counsel, if there's an issue with the clothing exchange, let the court know and we'll see if we can help expedite that.
Thank you very much.
All right, thank you. So we'll be back on April 11th and counsel, if you'll just sign the discovery acknowledgement.
Okay, no
right,
problem.
thank you.
Okay, all right, Mr. Miles. I'll be in touch with you, okay? Okay. All right. Yeah, oh yeah, I'm gonna take care of that. Okay. I guess we're waiting on the discovery.
Okay. Ricky Coleman. Good morning.
Morning, Your Honor.
All right, is this just gonna be a plea for one case?
Yes.
Oh, no, I put it back up there. Let me make sure.
Oh, you did, Judge.
Okay, no problem. All right, the court is calling 2023 CR 0894W State of Texas versus Ricky O'Hara Coleman. Can I have parties announced for the record, please, for the state?
Brittany Mitchell for the state.
Defense.
Woodrow Halsted for Mr. Coleman.
And are you Mr. Coleman?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Coleman, I'm going to show you what's entitled waiver of indictment, reading of information and rights on Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Did you understand that you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict?
Yes, ma'am.
And that your attorney has certain rights, namely 2 days from the presentation from the information and 10 days from the presentation of the information to prepare for trial. Did you understand?
Yes, ma'am.
Did you understand by entering this plea bargaining agreement, you were waiving or giving up those rights?
Yes, ma'am.
And did you intend to waive or give up those rights and enter into a plea in this case?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure, showing you what's entitled information. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
We do, Your Honor.
State, are you proceeding on the information as presented?
Yes, Your Honor.
Mr. Coleman, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand that you're proceeding on an evading arrest detention with a vehicle? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Okay.
Yes,
Did
ma'am.
you understand?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Coleman, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 8 years in the prison. They were taking consideration 2022 CR 9289, 2022 CR 9833, 2022 CR 9832, 2022 CR 9831. And there's to be no harmful or injurious contact with Deanna Coleman. State, have you informed Deanna Coleman of this agreement?
Yes, Your Honor.
And is
She's
she in
present,
agreement?
Your Honor.
Oh, she's present? All right. And she's in agreement with this plea?
She is in agreement with the dismissal of her case this morning.
All right, and I see Ms. Coleman in the back waving to me, signaling that she is in agreement to the dismissals of her case, of the cases involving her. And is she in agreement to the no harmful or injurious contact?
I believe so. She wants to maintain contact.
All right, and she's shaking her head to the court, informing the court that she wishes to maintain contact. Is that correct, defense?
That is correct, Your Honor. She would ask court for no order whatsoever in the case.
All right, did you understand that to be the plea, Mr. Coleman?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
All right, I'm gonna need you all to be quiet in the box. We're on the record. Counsel, are there any such motions?
No, we're not, Your Honor.
All right, then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence?
Your Honor, we offer state's exhibit number 1 and all attachments.
We reviewed it, no objection.
Thank you. And state, if you want to confer on other cases, you may sit.
Oh, okay.
Yes, you're welcome. Mr. Coleman, I'm showing you in what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
You know, we're just asking the court to follow the plea agreement. In the approximately 7 or 8 months that I've gotten to know Mr. Coleman, he's a really nice guy, and so just would ask the court to follow the plea agreement.
All right, court will follow your agreement, sentence you to 8 years in the prison, taking consideration 2022 CR 9289, 2022 CR 9833, 2022 CR 9832, 2022 CR 9831, and there's to be no harmful or injurious contact with Deanna, DEANNA Coleman. Give you credit for any time served. Is there anything else with regards to sentencing?
No, Your Honor.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Coleman, you're gonna have to make better decisions. You understand?
Yes, ma'am.
How old are you?
46.
You're getting to the stage where I'm already am, which is we have more of our life behind us than in front of us. Unless, I'm planning to live to be 120 or something like that. So you're gonna have to start making better decisions, okay?
Yes, ma'am.
All right, good luck to you. Thank you, counsel.
Thank you, Your Honor.
Very efficient.
All right, who is here on David Quinn?
Morning, Your Honor.
Good morning. So what is happening with Mr. Quinn?
Your Honor, we're requesting for time to review some discovery. We gained access to discovery on Wednesday, about 27 videos. Defense needs some time to review the videos. The state has submitted an offer to us today. We just need some time to review it to see what we want to do.
All right, so do you have all the discovery?
I believe so, Your Honor. The only concern is we may be missing some surveillance videos. But I'm gonna review the 27 videos today or this weekend and let the state know one way or the other.
All right, so Ms. Ferguson, can I have a 30-day reset on Mr. Quinn?
Yes, March 21st.
All right, we'll be back on March 21st, and that will be your final discovery. On that date, I'll need to have the discovery acknowledgement signed.
Yes, Your Honor, we have one today if you'd like it.
Oh, well, I wanted to make sure that you had all your discovery. You're telling me you don't know if you have everything
Okay,
because you haven't had a chance to review it. Am I correct?
that's correct, Your Honor.
All right, so what we'll do is we come back on March 21st. I've already noted in the file that the state has tendered an offer to you. So on March 21st, when you come back, I'm going to want the acknowledgement of discovery signed.
Yes, ma'am.
And then I will give you a quick turnaround date for a plea deadline date, okay?
Yes, ma'am. Sounds good.
All right, is there anything else?
I think we're good.
All right, thank you.
Thank you, Your Honor.
You're welcome.
Judge, do you need to sign off on these acknowledgements?
Yes. And then you are excused.
Okay, great, thank you.
You're welcome. Who's here on Mariah Rodriguez?
That was Sunny. We were just about. She's the one that's in lifetime.
All right, so-
She's gonna get with lifetime and see when they can zoom in. And she'll call me and tell me.
Daniel Macias. Thank you for addressing appropriately for court. So what's going on with this case?
Your Honor, I believe we're here on our plea deadline. We have not been able to reach an agreement. The final offer from the state has been rejected, and so we're gonna ask to set this for a jury trial.
All right, state, how long do you expect this jury trial to last?
2 to 3 days, probably closer to 2 though, Judge.
All right, Ms. Ferguson, on Daniel Macias, I need a jury trial date. Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you'll have to plea open to the court. Do you understand?
March
Yes, Your Honor.
21st.
All right, we'll come back on March 21st. Ms. Ferguson will give you a reset form. Alexander Castro.
Your Honor, I'm here.
All right, if you can come forward, please. Thanks for dressing appropriately for trial. So where are we on this case?
Your Honor, I think we're on a first setting. We've just been hired. There's, it's a pretty involved case involving a lot of scientific evidence as well as, I guess, as well as ballistic or CSI type evidence because of a car crash. I can't even tell the court right now that we have all the discovery because we're still going through it, and that's kind of how we figured that out, what we have and what we need. So we need more time.
All right, Ms. Ferguson, can you reset Mr. Castro for 30 days for discovery, please?
21st March.
Okay.
All right, March 21st, Ms. Ferguson will give you a reset form, then you're excused.
Thank you, Judge.
You're welcome. Who's here on Noah Guerrero? Guerrero? All right, if you come forward, please. And Ms. Abrams, this is for probation. Court is calling 2023 CR 0059, State of Texas versus Noah Guerrero. Can I have parties announced for the record for the state?
Daniel Escobar, State of Texas.
Defense.
Robert Gaona.
And are you Mr. Guerrero? Counsel, have you received all the discovery in this case and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Guerrero, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? Did you sign it? Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we're proceeding on count 1 and waiving count 2.
Any objection?
No objection.
Mr. Guerrero, I'm showing you what's entitled court admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
I did.
Did you understand you're charged with theft, 2,500 to 30,000 of a vehicle? That's state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes,
Did you understand you have a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? All right, I'm gonna need you to speak up.
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent, was legally sane at the time of the offense?
Yes, I do.
Mr. Guerrero, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
All right, so I'm gonna need you to speak up.
Yes.
All
ma'am.
right. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yeah.
According to plea, state is proceeding on count 1. Punishments to be assessed at 2 years in the state jail facility. There's a $500 fine. State recommends community supervision. Counsel, there's no application for deferred. Is that correct?
That is correct.
All right, and this is the right concurrent with County Court Cause number 66052. Did you understand that to be the plea?
Yes, ma'am.
Defense?
It is, Your Honor. I believe the $500 fine was to be probated.
Yes. All right, did you understand this to be the plea?
Yes, ma'am.
State, is this the plea?
Yes, Your Honor.
Next, I'm showing you what's entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving the right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea. State is requesting that your supervision be for a term of 4 years and there'll be 100 hours of community service restitution. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation?
Yes.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's no contest plea?
State offers State Exhibit 1 in all attachments.
Any
No objection,
objections?
Your Honor.
All right, state, you can go handle more cases.
Thank you, Judge.
You're welcome. Mr. Guerrero, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in both places?
Yes, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written. I'm sorry, just one moment. There was some major laughter in the hallway or something. It's fine now? Okay. All right. We're starting over. I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Would ask the court to follow the recommended plea bargain by the state, Your Honor.
All right. How old are you?
23.
Are you employed?
No, man.
How do you support yourself?
We're here and there where I can, like construction.
Who do you live with?
I live with my mom.
What's her name?
Lillian.
I'm sorry, what?
Lillian.
Lily what?
Lillian.
Lillian.
Guerrero.
Does she want you living with her?
So far as I know, she has no problem.
Do you have any siblings?
Uh,
Brothers, sisters? Do you have any?
I do. I have
What are their ages?
my older brother's 25. I have a younger brother. He's 19. I have another brother. He's 18. I have a sister that is 17. And a little brother that's 16.
And are all of you all living with your mom?
No.
How far did you go in school?
10th grade.
I'm sorry.
Couple,
Why did you drop out of school?
work.
Yeah, but you don't work. That doesn't make any sense. Why did you drop out of school?
I worked then. I stopped working because of my seizure disorder.
Seizure disorder.
So you can't do class, but you can work. So you can't go to class because of your seizure disorder, but you can work. Is that what you're telling me?
He just stopped at a point.
Do you have any children?
Yes, ma'am.
How many?
1,
What's the age?
3.
And where is that child?
My with her mom.
With your grandmother?
With her mom.
With her mom?
Yes, ma'am.
So we have two children who are not, well, you're not a child anymore, you're 23. So neither of you all are raising the 3-year-old.
Yes, my girlfriend is.
No, her mom is. She lives with her mom. None of you are supporting this 3-year-old. The 3-year-old is not living with you. You're not paying child support, but you're gonna pay child support because according to the rules of probation, you have to support your dependents. Do you understand?
Yes, ma'am. I do.
All right, have you ever used drugs in the past? All right, this is what the court is going to sentence you to 2 years in the state jail facility, suspended and probated for 4 years. There's a $500 fine that will be probated. This will run concurrent with County Court Cause number 660452. 100 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to do that, but if you do, 40 of those hours will be waived. I'm going to want parenting classes. Triple P. Once you complete that, the remaining of your hours will be waived. You're either going to get your GED or go to some sort of trade school. You need to find an occupation where you can support yourself. That means not depending on your mom to provide housing for you. That means you supporting yourself. You understand?
Yes, ma'am.
I'm going to want regular reporting by Zoom or in person. There should be no unsupervised contact with minors. Counsel, I'll reconsider that once he's completed parenting classes or has done something in parenting classes. I'm going to want field visits 2 times per month, and probation, that can count as his reporting if you want it to count as his reporting. And we'll do regular UAs. Probation, is there anything else he needs? Is there anything else you need from the court in order to be successful? You need anything else from me?
No, ma'am.
All right, I'm showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. This is Texas. Do you know how many times people get shot or get injured because they're taking someone else's property, especially from a driveway? Do you understand that? So you're gonna have to get a job and stop stealing, all right? Good luck to you.
Thank you.
You're welcome. Who's here on Christopher Davis? Who's the attorney for Christopher Davis?
Mr. Barron.
Mr. Barron, I just got a text him that he's out here already.
Okay. Caitlin Martinez? Yes. All right, what's happening with this case?
This is a continuation of the sentencing that we had about 2 weeks ago.
Yes.
You had asked that we contact the CCF in Uvalde to see if it was possible for Miss Martinez to be in inpatient treatment there. Those people never answer their phone and they never return phone calls. I've tried all of the extensions that they give me as an option. So I apologize for not.
Oh, no problem. It's not your fault.
Thank you.
So I did have a TAP evaluation done. They're recommending a dual diagnosis. They want her evaluated for DGRF.
I understand, Judge. Excuse me. The plea bargain was for a year deferred. And my understanding from probation, and it could be less time, is that it would be about 2 weeks to have the evaluation done, and then another 4 to 8 weeks before a position is available for Miss Martinez. And then we've got maybe 8-9 months left of the probation.
All right, so here's my thing. She is going to be living in a different county, correct?
Correct, Rio County.
All right. So she need, I mean, do they have Center for Healthcare Services, something of that nature there? Because that's what this is suggesting that she needs.
Judge, the last time I was here, I called their probation department, adult probation, and they said that the resources that they use are the same as Bear County's. So I don't know if that meant they didn't have a clinic like MHMR.
All right, how far is that place from here?
It's 52 miles.
All right, so will you be able to come back for Center for Healthcare Services here if I order that? Because,
Part of their vehicle, I mean, right.
all right, because I just can't, I don't feel comfortable sending her off into the world when I know she needs mental health treatment. And I'm sending her off in the world saying, good luck to you. I know you need this, but we're not giving it to you.
I understood, Judge, and we've been trying to figure out that same dilemma. I know this is kind of a hope and a prayer, but one thing may be as a condition that she physically go to that facility in Uvalde. And maybe she can get some answers in person and report back to probation here by phone, what she found out, have some.
All right, let's do this. This is my suggestion. My understanding is that I know there's a misdemeanor court mental health, and there's also felony court mental health. I know they do it as a pretrial diversion type of thing.
You're talking here in Bear County?
Yes. Could I see the state on Miss Caitlin Martinez? All right, this is a case that you all entered into a plea where you reduced it to a possession less than a gram. And I don't know, this is just me talking out of the box. I don't know if there's a possibility of her being considered for the mental health. They're saying the mental health, they only do pretrial diversion, the felony. So I don't know if y'all would consider that. I don't think she's going to be successful in probation if I just send her out of this court, knowing that she needs mental health treatment because they're recommending a DDRF evaluation.
Okay.
So I don't know if that's something the state is willing to look into, if that's something you all are willing to look into. I don't want to interfere with your plea negotiations, but I just would feel badly sending her into the world to fail.
And she wants some type of residential treatment. That's what she's asking for. It's finding the right situation under this.
I can take a look at it real quick. Judge, if you
Okay,
don't mind.
all right, so we'll have him take a look at it, and then it may be a situation where we can refer it to mental health. And then if y'all come to an agreement, we'll let mental health know that you all are asking for sort of like a pre-screening, and depending on what they say, maybe something else will happen with this case. All right, so just check on that, and it sounds like we're probably going to end up with a reset, but I think it's better for us to get it right than send her out into the world to fail.
Absolutely. Thank you, Judge. Appreciate it. You welcome.
Eric Gonzalez Lopez.
Yeah, I think the bailiff's gonna get him, he's inside the door.
Oh, okay, I thought he was already out here.
He was outside, but.
Okay.
was in here, we just needed room.
Okay.
He's on the camera.
And then after this case, it's gonna be Guzman, then Fernando Carmona.
You have Andrade also, Judge.
We will see if I have that.
Been up there since about.
No, because I put them in order and I put them, and you said Andrade?
Robert, yeah, I'm trying to make it to one. What she did?
Yes.
Well,
We're efficient here.
Well, I didn't know if you still wanted to know the status of the case, Judge, because that's what you normally do.
Okay, all right, we're efficient here.
We're happy to leave,
Okay.
but we didn't get a new partner, so.
And Your Honor, I have a student interpreter with me today.
Hi, I've seen him before.
Good to see you again, Your Honor.
You too. All right, so we have an interpreter here for Eric Gonzalez Lopez. Counsel, is your client a citizen or no?
No, Your Honor,
All right, so does he need an immigration attorney?
not quite there yet, Judge.
Well, I mean, it's like.
Yes, he will, if the court's gonna appoint, yes, of course.
All right, so Norma, I needed immigration for Mr. Gonzalez. All right, Mr. Gonzalez, the court is going to appoint you an immigration attorney, but that immigration attorney is only your immigration attorney as it relates to this criminal case. They're not to handle any global issues involving your status in the country. Do you understand? Yes. All right, so where are we on this case?
Judge, we just got our first offer today. I've communicated to my client. We are not accepting it today. I think it's only.
Do you have all the discovery?
I haven't gone all the way through it, Judge. Just to start second setting, it's quite a bit. There's four defendants in this case, and the state has informed me this morning they may be re-indicted.
All right, Ms. Ferguson, can I have a 30-day reset on Eric Gonzalez Lopez, and we'll put it as discovery? All right, we'll be back on March 21st for discovery, and hopefully the state will be able to let you know what their plans are.
Ms. Rose.
Okay.
And Judge,
Your immigration attorney is going to be Teresa Pose Davila. Yes,
I think all the four defendants were set today. I'm guessing we're gonna all be on the 21st again.
yes,
Thank you.
but they still need to show up.
Understood.
Thank you. Okay, all right, is there anything else?
No.
All right, Robert Andrade. Thank you for coming. Is Robert Andrade in custody or on bond? All right, what's happening with Mr. Andrade's case?
Judge, we've conferred many times about his case. We are ready for trial.
Okay, state, how long do you expect this trial to go?
Oh, multiple instances, so probably about 4 days.
All right, Ms. Ferguson, can I have a jury trial date for Mr. Andrade? And Mr. Andrade, your plea deadline date has expired. The court will not accept any plea bargaining agreements in this case without good cause. Otherwise, you have the plea open to the court. Do you understand?
April 4th.
All right, we'll be back on April 4th for your jury trial. Ms. Ferguson will give you a reset form.
Thank you.
Frolan Guzman. Guzman, going once.
Yeah, oh, Judge, I think the other sentence in that was by accident.
Okay. Oh, no problem.
And that's Mr. Leal's client. I don't know where Mr. Leal is.
All right, Fernando Carmona.
Judge, just so you know, I think we're ready to resume the MCR.
Okay, all right, thank you. All right, court is calling 2022 CR 9805, State of Texas versus Fernando Carmona. Could I have parties announced for the record for the state?
Jason Dorkins for the state.
Defense?
Alfred Ramirez on behalf of Fernando Carmona.
And are you Mr. Carmona?
Yes, Your Honor.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Carmona, I'm showing you what's entitled application for deferred adjudication. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do waive, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving count 2 and proceeding on count 1.
Any objection?
No objection.
Mr. Carmona, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney?
Yes,
Did
Your
you
Honor.
understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of aggravated robbery? That's a first degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Carmona, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, state is proceeding on count 2. There's a $1,500 fine.
Judge, I'm sorry, we're proceeding on count 1.
Oh, sorry, thank you. State is proceeding on count 1. There's a $1,500 fine. State recommends deferred adjudication. This will run concurrent with adjudication and a judgment satisfy conviction and county court cause number 6435552. State will take in consideration CM number 83864, 658859, JN number 1979614. There's restitution, if any, to Miguel Zapian, Zapian, and there's an affirmative finding of deadly weapon. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver repeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counselor, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 10 years. There be a TAP evaluation, 200 hours community service restitution, no contact with Miguel Zapian, no firearm possession, the MRT, and regular UAs. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's plea?
Yes, Your Honor. The state offers Exhibit 1, the defendant's waivers and stipulation of evidence, as well as the discovery option for this case.
No objection.
All right, state, you may continue conferring.
Thank you, Judge.
All right, Mr. Carmona, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. So defense, why should I go along with this plea?
Your Honor, when this offense occurred, Mr. Carmona was 18 years old. And I know that the facts are pretty bad. Mr. Carmona is, not to minimize it, but his main goal that day was simply to break into the vehicle. There was no, he didn't know. So basically he broke in, and I know you read through the report, but
Yes.
The person came out, was beating him up, and then that's when the other passenger shot.
I mean, so why people don't think they should get beat up when they're stealing somebody's vehicle?
No, I think I should have got beat up. I didn't think he was in the wrong at all. I was definitely in the wrong.
It was, he didn't know that the other passenger, who happened to be his brother, was going to shoot the victim in this.
Where's his brother?
His brother is
he in custody? Where is he?
He's just at home. I think he's on the run for a different charge right now.
Okay.
Yeah, I'm not exactly sure, Judge, on what happened to the brother, on why he wasn't charged. But since then, and I guess Mr. Carmona he dropped out in 9th grade, hasn't really been gainfully employed really ever. Since then, he's grown up a lot. He has a child, a 1.5-year-old child. Maybe that might have been the child you heard in the hallway.
Well, I mean, I know he has a child because the proceeds of this was used to go shop for diapers. That's what the police report says.
Yes, I think at that time it might have been somebody else's diapers, because I think the child was born shortly after this offense has occurred. But since this offense, he has grown up a lot. He hasn't had any violations. He's been on the monitor. He's been cooperating, coming to every other court sentences.
Where are you living? Who are you living with?
My grandmother.
And is your brother living there?
No.
Are we gonna have any drug issues with you?
No, ma'am.
So what are you planning on doing with the rest of your life?
Just being able to just have a normal life and just be able to have my own home and car, and that's it. Because like right now I'm just financially struggling with my family, and I haven't really been able to get a good job because I don't have my social security card and I can't get an ID. So I've just been working like whatever I can.
And you only have a 9th grade education. That's a problem. All right, this is what the court is going to do. I'm going to need everybody to be quiet in the box. Court is going to sentence you to 10 years deferred adjudication. There's a $1,500 fine that will be probated. This to run concurrent with the judgment satisfied and cause number 6435552. Taking consideration CM 83864, 958-859, Jan number 197964. Restitution, if any, to Miguel Zapian. There's an affirmative finding of deadly weapon. And state, is the complainant aware of this agreement?
Yes, Your Honor. I believe so.
All right, thank you. And there's to be no contact. There's to be no contact with Nicholas, Nicholas Carmona. What's your grandmother's name?
She's actually my step grandmother, so I really don't know much of her. I did know her for like most of my life, but I really don't know her.
But that's where you're living?
Yes.
All right, probation. We need to get the address of his step grandmother. That's where he's gonna reside. You to reside with your step grandmother.
Okay, we're on the record.
200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to do that. But if you do, 40 of those hours will be waived. I'm gonna want parenting classes with triple P, then the remaining will be waived. There's to be no contact with Miguel Zappian. No firearm possession, that goes without saying. The MRT, regular UAs. He can do partial GPS for work only. We'll start out with that and see how that goes. And there's to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be regular reporting by Zoom or in person. I'm going to want field visits 2 times per month. In probation, you can use those field visits as his reporting, and that's until further notice. You're going to either obtain your GED or either get some sort of certification in a trade school. You understand? Probation, is there anything else he needs? Is there anything else you need from the court in order to be successful?
Yes, sir. No, Your Honor.
All right. All right, did you review the document with your attorney entitled Trial Court Certification of Defendants' Rights to Appeal? Did you sign that? Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal.
I'm sorry, Your Honor, just one thing on the GPS, the continued GPS. I'm not sure right now if the fees are waived, but he is struggling financially, if at least for a period of months, if some of those could be waived.
Now, we can ask probation if you could see if they can be deferred,
Okay,
but whether they do that or not, it's a third-party contract with a third-party company.
okay.
So because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because according to the plea bargain agreement, you're not allowed to own any weapons or ammunition. You're not allowed to own any weapons and ammunition on probation anyway. But you're now being told specifically you cannot. You understand?
Yes, Your Honor.
Do you have any questions about anything?
No, Your Honor.
All right, good luck to you. Yes.
Judge, do you have Caitlin Martinez file on the bench by chance?
Yes.
Could we review it?
Yes. Thank you so much.
Any questions?
Yes. All right, is the person here on Christopher Davis? Nope. All right, Guillermo Rodriguez. We're slowly working our way through. Mejia, but it's still Friday, so that makes it okay. All right, the court is calling 2022 CR 10587, State of Texas versus Guillermo Rodriguez. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense,
Eric Hernandez for the defendant, Guillermo Rodriguez Jr.
are you Mr. Rodriguez?
Yes,
Counsel, have you received all the discovery in this case, and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Rodriguez, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We waive, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Rodriguez, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did
Yes,
you
Your Honor.
understand it? Did you sign it in all the appropriate places?
Yes.
All right, just one moment. Deputy, could you have them move to the other box down at the end? All right, did you understand what you're charged with is burglary of a habitation force? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call them the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand that the court would have granted your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do believe so, Your Honor.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review it with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $500 fine. State recommends deferred adjudication. They will take in consideration 2022 CR 10587. And there's restitution to Dionisio, Dioncio Hernandez. Did you understand that to be the plea?
Yes, Your Honor.
Defense,
Yes, Your Honor.
state,
Yes, Your Honor.
showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that the deferred adjudication be for a term of 5 years. There be a cop evaluation, 100 hours community service, restitution, and no contact with Dionisio Hernandez. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offers states exhibit 1 in all attachments.
No objections on the
All right,
defense, Your Honor.
state, you may be excused.
Judge, here's a dismissal.
Thank you. All right, Mr. Rodriguez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney, counsel? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand again, that you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call them the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. However, the court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, Mr. Rodriguez will be living with his father upon his release and will be seeking to find employment with Taco Cabana where he was working before he was arrested on this charge. He believed he would be productive and comply with the rules and regulations of probation and would ask the court to honor the bargain agreement. Thank you. There's no minors at the home. No, there's no minors in that home. Your Honor.
Okay, just 1 moment. No, I'm sorry, Caroline. I don't have the file for 2022 CR 10588. It's this case. Guillermo Rodriguez. I have the 057. I have that. All right, anything you wish to say?
No.
All right, why are you breaking into someone's house? I guess that's your occupation.
No.
Well, I mean, it was your occupation on that day. So why are you breaking into someone's home?
I was in a bad spot in my life.
A lot of people are in bad spots in their life. They don't break into somebody's home. And it was mighty bold of you to come out of the house actually wearing the person's clothes.
That was the police report says.
So how do you not know what it says? I mean, you were there.
I really went in there to take a shower and eat. I was homeless at the time.
So
I'll be
you
honest
think that
with you.
gives you a right to
No,
break
it
into
doesn't, it
somebody?
doesn't. No, ma'am.
So why are you doing it?
I was hungry and then I was tired. I wasn't thinking right. It was hot. It was in the summer.
It's always hot in the summertime in San Antonio, but I don't see other people breaking into people's homes.
I know, I understand.
All right, anything else?
No, Your Honor.
All right, this is what I'm sorry, can I have a stand? Okay, thanks. All right, this is what the court is going to do. The court is going to sentence you to a $500 fine. That will be probated. Taking consideration 2022 CR 10587. Restitution and no contact with Dionisio Hernandez. Six years deferred adjudication. 100 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination. But if you do, 40 of those hours will be waived. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. Regular UAs. Regular reporting. Where are you going to be living?
And my father,
Right. What's your father's name?
Guillermo Rodriguez Sr.
All right, he's to reside with Guillermo Rodriguez Sr. And if you just want to move from that residence, you have to get permission. Do you understand?
Yes.
I'm gonna want field visits 2 times per month until further notice. The MRT. And 60 days in the Bexar County Jail as condition. Probation, is there anything else he needs?
No, Your Honor.
Is there anything else you need from the court to be successful?
No.
Your Honor, for clarification, will he get credit for time served for those 60
No.
days? And Your Honor, for clarification, if he does get his employment back at Taco Taberna, if they employ minors, is that considered working with minors?
No.
Approval.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Did you sign it?
Yes, Your
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, good luck to you. Who's here on Lopez Benitez? All right, I'm sorry.
I'm sorry.
It is Randy Lopez Benitez. Thank you. And can I have the interpreter, please?
Yes, Your Honor.
Hi. Bonjour. All right, State, I'm just gonna give this the same date as I gave the other one.
Sure. Thank you.
All right, is your client going to need an immigration attorney?
He will, Your Honor.
All right, Norma, we need an immigration attorney, please. All right, Mr. Lopez, what's going to end up happening in your case. We're going to bring it back on March 21st for discovery. I was informed on the co-defendant's case that there may be more discovery and different charges may or may not be filed. So we're going to come back on March 21st. An immigration attorney will be appointed for you. That immigration attorney is only your immigration attorney as it relates to the impact any action you take on this case will have on your immigration status. Do you understand?
Yes.
Yes.
All right, is there anything else?
Not understood.
All right, thank you. They'll get an immigration attorney for him.
Thank you, Judge.
Thank you. Thanks for coming down. Who's here on Brandon Wright? All right, what is happening on this case?
I've been confirmed with Mr. Villarreal. There's still some discovery off of a laptop I think we're waiting on.
Yes, Judge. So there's a laptop that has been turned over. We don't have the result. It's not on this case. There was an outlaw case. It was filed with a different victim on it, child victim. I've given him everything that we have on that case. So it's just, I know there is a laptop within their possession that they're doing a search. They have, my understanding is they have done the search warrant on their process of extraction. I don't have an update as far as time or estimated time.
Okay, all right, Ms. Ferguson. I need a reset date on Wright for discovery. We'll just bring it back in 30 days. Okay, I'll give you your setting. We're gonna bring it back on March 21st.
Okay.
And
You don't
your
have a
client can appear by Zoom.
Thank you, Judge.
All right, and they'll give you a reset form. Oh, you don't need a reset.
I don't need
form.
one. We're good.
So it's March 21st. So Mr. Wright, we'll see you back on March 21st for discovery on this laptop extraction.
Thank you, ma'am. Excused.
Yes,
Thank you. Thank you, Mike.
yes.
Approach her.
Mhm.
Jason.
Yes.
Miss Martinez. I messed up on the plea bargain. The plea bargain was for 1 year deferred. This is a state jail felony. And that would be illegal, although I've done some legal things. I'm not in-
Hold on, you're on the record.
Yeah, no, we're not on.
Okay.
Yes.
Let's take it.
I try not to do them in open court. So we have to amend that. Also, since we have to reset, my suggestion is that with the court's permission, my client actually go to that facility in Uvalde. And while she's there, have the person in charge of admitting call me so that I can have a phone conference with Ms. Martinez there and admittance, and maybe we can still work something out. Now that we're looking at a minimum of 2 years.
Okay, and I will say this, that and on your plea bargain page, there's no years written.
That's one that we were looking at. Judge.
Okay,
And I was like, unless something's changed since protocol.
No.
Grand jury. It was.
okay, so here's my question. Let's say she goes there, or they say they can't help her. So shouldn't we also look at the mental health here as well? So, all right, so let's do that. So how much time are you asking?
Well, according to Ms. Probation Officer, I forget her name, Sean, it's gonna take 2 weeks just to have her evaluated. So maybe 3 to 4 weeks.
All right, Ms. Ferguson, on Caitlin Martinez, can I have a 1 month reset?
March 21st.
All right, so we'll come back on March 21st. You'll need to sign that and we'll have her evaluated for mental health court as well.
Good idea. Thank you, Your Honor. May we be excused when we sign that?
Yes, but she needs to, Norma, make sure she gets the referral to mental health court. Okay, all right, thank you.
And this is the court's.
Thank you. It's reset for March 21st. Yes,
Your Honor, may I approach one more thing?
yes.
The location in Uvalde is outside of the radius Miss Martinez ankle monitor. Could we get some type of,
Just call them and let them know that the court gives her permission to go to that facility. Okay, sure. Victor Garcia. Yes. All right, what is happening with Mr. Garcia?
Your Honor, this is the first setting. I've spoken to my client. He's had some indications of some prior mental issues of being hospitalized and that he's on medication. I would like to be able to make a motion to have him evaluated for competency.
All right, Ms. Ferguson,
Yes, ma'am.
I need a reset on Garcia for 30 days and it'll be the status on the competency, but just make sure you get it filed.
I will file for it.
All right, what date, Ms. Ferguson?
The 23rd.
All right, we'll see you back on March 23rd.
Thank you, Judge.
You're welcome. Pedro Alonso.
Excuse you.
Yes, you may. Pedro Alonso, who's the attorney? Come forward. So what is happening with this case?
Your Honor, on the discovery, I have access to it. It's very voluminous. I would say at a minimum, several hundred hours of videos and audio interviews and recordings. I've gotten through a big portion of it. A lot of it's still being downloaded. So we'd love to see if we can have one more pretrial reset. And then also in conferring with the state, it's my understanding that they may re-indict. They're going to seek some re-indictments from the grand jury. It's my understanding.
All right, Ms. Ferguson, on Pedro Alonso, can I have a 45-day reset?
And Your Honor, right now, he's currently on a GPS partial for employment. He's having a really hard time. He's a landscaper and the landscaping company kind of goes from job to job. And the pretrial office says that he needs to just have one address where he goes, like he can't be jumping
All
around.
right, file a motion and the court will hear it.
Okay, thank you.
All right, what date, Ms. Ferguson?
We can do March 23rd.
All right, we'll be back on March 23rd.
And I think I have filed the motion, but you want me just to set it like?
Yes.
Okay.
Jose Ruiz.
Good afternoon.
Good afternoon. All right, counsel, you filed a motion to withdraw?
Yes, Your Honor, that's what we're approaching now. I'm sorry.
All right, the court is calling 2022 CR 4248A, State of Texas versus Jose Angel Ruiz. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense.
Deborah Stantonberg.
Are you Mr. Ruiz?
Yes, ma'am.
Your attorney's filed a motion to withdraw. Do you have an objection? All right, state, do you have an objection to the motion to withdraw?
No, Your Honor.
All right, motion to withdraw will be granted. Thank you.
Thank you.
All right, Mr. Ruiz. No.
Oh, I'm sorry.
It's okay. Are you able to hire an attorney?
Honestly, do not know.
I'm sorry?
Honestly, do not know. I have to speak to my family.
All right, Ms. Ferguson. I want this reset in 3 weeks. If you're going to hire an attorney, you need to have one hired. Otherwise, we'll see if you're eligible for a court-appointed attorney. All right, what date, Ms. Ferguson?
3 weeks. I can do March 2nd.
All right, so we're going to come back on March 2nd. Thank you. Isaiah Verju.
Well, no, we confirmed it wasn't. Oh, okay. Please.
Are you guys ready? Okay, what's happening with discovery on this case?
Yes, Your Honor, we were reset from the last time because when we came in here, I didn't realize that I was gonna be taking on the case and I did not have the court's answers with regards to discovery. I did pull the file, we do have the CPS case records that were previously requested, as well as the cell phone information. So I still need to review it, but it is there and it is working.
All right, has an offer been tendered?
I believe so, Your Honor.
All right, Ms. Ferguson, on Verju, can I have a 4-week reset for a plea deadline date, please?
I can do March 7th.
All right, March 7th is your plea deadline date. After that, the court will not accept any plea bargain agreements without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes, ma'am.
All right, see you.
Thank you. I didn't even see.
Jacob Moria.
Moya.
Morning.
Good morning. What's happening with this case?
If we just want to bring him back, they've been off for this, but we want to bring him back Monday to see which topic.
All right. Ms. Ferguson, are you able to recall him back on Monday?
Yes, ma'am.
All right, we will see you back on Monday.
Thank you.
You're welcome. Roland Guzman. Christopher Davis. Roland Lopez.
Hey, Judge,
Hello.
talk about your long-suffering Dallas Cowboys fans. I'm a Houston Texans fan.
All right, we're back on the record in 2018 CR 0165, State of Texas versus Roland Lopez. I believe we were still on direct examination of the witness, Ms. Deshawn Abrams. Is that correct?
Yes.
All right, States, you may continue.
Trying to remember where we left off. Ms. Abrams, I think we were talking about the violation of condition number 4 for failing to provide proof of employment. Prior to this allegation for failing to show proof of employment on November 17, 2022, when was the last time that Mr. Lopez had provided proof of employment?
July of 2022.
And did he provide proof of employment for the month of November 2022?
No, he did not.
What are the conditions of probation? How frequently is a probationer, or and specifically Mr. Lopez, how frequently must he provide funding?
The condition state must provide based on at request of the supervision officer. Typically, we, as a rule of thumb, we get it every 30 days, every 30 to 60 days.
And do the defendants receive a reminder to provide proof of employment or proof of residence?
Typically, that's done on each office visit.
Is there any kind of automatic system for that?
There are text messages that go out. I can't tell you the frequency of this case by case basis.
And continuing on this November 17, 2022 interaction, there's an allegation that Mr. Lopez was not conducting himself in a properly and orderly manner in violation of condition number 5. What was Mr. Lopez doing during that interaction that was not in accordance with an orderly manner?
And Judge, I'm gonna object again under hearsay, confrontation clause, and they failed to lay a predicate for a business record affidavit or a hearsay exception under a business record affidavit. Generally speaking, in this specific instance, it's going to require confrontation with the witness as to which specific conduct Mr. Lopez displayed on that Zoom that was neither recorded or memorialized. This witness has no personal knowledge as to anything that was going into the this Zoom, doesn't say anything about, can't say anything about Mr. Lopez's demeanor or anything like that. And I think any testimony that absent Ms. Cisneros being present to testify to it should not be admitted, and it certainly should not be given any weight.
I don't know if it was Zoom or not, because I haven't heard any evidence yet.
And regardless of the nature of the communication, my objections still stand.
All right, that'll be overruled.
And Judge, if I can approach, just in the interim, we did find a case related to the confrontation clause objection, which I've tendered to the defense previously, showing out of the fourth court that the confrontation clause does not apply in a revocation.
And Judge, my argument is, in light of that, we're still in a specific situation where it would require the personal knowledge of Ms. Cisneros, who is not present in the court and is the only person that could testify as to a lot of what was conducted during that hearing.
All right, that objection will be overruled. You can answer the question.
The notes indicate that the defendant was reminded that he's required to make his payments and he was required to make his monthly payments. And during the meeting, the defendant became argumentative at times when CSO asked about his compliance of UA testing and monthly payments. The defendant reported he is tired of each officer telling him the same thing and he would like to have a compliance hearing. Upon review, a supplemental report was submitted to the court.
Objection, this is going beyond the interaction on Zoom.
That'll be sustained.
All right. And Ms. Abrams, at the time that that this interaction happened on November 17th, 2022, was Mr. Lopez under zero tolerance supervision?
Yes, it was.
What does that mean?
Zero tolerance means zero tolerance, to be in compliance of all conditions of probation at all times.
So in that sense, is it fair to say that any violation would be a violation of zero tolerance?
That's correct.
Let's turn now to June 30th of 2022, the first allegation that we have on the motion to revoke. There was an allegation of failing to submit drug testing. Was Priscilla the first probation officer that Mr. Lopez had?
No, she was not.
Do you know who the probation officer was at the time of the June 30th, 2022 violation?
One moment, please. I'm sorry, can you repeat the date?
June 30th, 2022.
I would have to go back to that date in the file, I'm sorry.
Okay. Is there an indication in the probation file about Mr. Lopez being instructed to submit a drug sample, or I'm sorry, a UA specimen on that day or around that day?
Mr. Lopez did not report for the month of June in 2022. However, he was on monthly UAs and knows that he should have submitted.
He was required to submit every month,
That is correct.
and he did not report it out.
That's correct.
Was there any indication that he submitted a drug specimen in the, or a UA specimen independent of his reporting to probation?
No.
We'll pass on this. Judge.
All right, defense.
All right. Okay, so per your testimony, there was no specific request that he submit to a drug test on June 30th, 2020.
That is correct.
Okay, and he did test in May of 22 and in July of 22, right?
Objection to documents.
That'll be overruled.
That is correct.
And he tested negative.
Oh, I'm sorry, 1 second. That is correct.
And he tested negative on both of those occasions, is that
That is
correct?
correct.
Okay. Now. On November 17th, 2022. There was a specific request that he give a sample on November 17th, given by Miss Priscilla on that Zoom. Is that correct?
That's correct.
Okay. And there was no, from your testimony, there was no reminder before that date,
Before,
November 17th. Between October 28th and November 17th, 2022, there was no specific indication that he was supposed to provide a sample on that particular day of the Zoom meeting.
he was told on the Zoom meeting, but between those times, no,
Okay.
no indication.
And he did provide a urine sample on October 28th, is that correct?
October 28th, that is correct.
And he also provided one on November 30th, 2022, is that correct?
November 30th, 2022, that is correct.
Okay. Now, regarding the proof of employment. Does it say anywhere in the records that Mr. Lopez has been employed at the same employer, Freeman Expositions, since 2017?
I do not have that in the records that I have in front of me. I would have to review court file for that.
Okay. And generally speaking,
However, they are,
objection, not responsive.
All right, you can finish your answer.
however, as a condition of probation, regardless how long they've been working, wherever they've been working, you're supposed to provide proof of employment.
And he had most recently provided proof of employment prior to November, was in July of 2022.
That's correct. With the ending date of June of 2022. The the check stub ended in June of 2022.
And he had never given any indication that he had lost his job, changed jobs, or anything like that.
I don't have notation of that now.
Okay. Now, on violation, condition number 9A, it's alleged that he failed to report a change of address, job, or an arrest within 48 hours. Is that correct?
That is correct.
Okay, and there was no change of address, no change of job, or any arrest that he could report. Is that correct?
We can't verify that because when the field visits were completed, we could not do a adequate field visit because he was not there.
But you have nothing in your files or anywhere saying that he had a change of address that he didn't tell you about, a change in job that he didn't tell you about, or any arrest that he didn't tell you about.
According to my records, there was several field team visits. And the mother of the defendant. who lived
Objection,
in-
we're going into hearsay of hearsay of hearsay at this point.
All right, with regards to anything the mother said, that objection will be sustained.
So they also said on September 16, 2021, that defendant failed to permit the supervision officer to visit defendant in his home or elsewhere in violation of condition 52. In your chronologicals for September 16, 2021. Says, or sorry, on September 8th and September 14th, there were field visits at his home.
Right.
Okay, so on 9/8, 9/14, we have successful field visits, and then on September 21, Mr. Lopez was at work at the time. Correct?
I don't know where he was. It doesn't, I can't tell you where he was at the time.
Okay. Now, you can't testify to anything about the nature of Mr. Lopez's interaction with Priscilla Cisneros on the Zoom, or on the 13th, or the 13th of July, or November the 17th, 2022. You can only go by the notes, right?
That is correct.
All right, and in the notes, you stated that he was argumentative as to a misunderstanding about his conditions of probation, right?
That's correct.
Okay, and it says, does it say anything about Mr. Lopez raising his voice?
On the you mentioned two separate
Well, this
dates
focus on
on
the
11,
17th.
17. No, it does not say that.
Does this say anything about him using cursing?
No, it does not.
Does it say anything about him insulting Miss Cisneros?
No.
Now, the same applies to July 13th, 2022. Did he Insult, Mrs. Naris?
Yes. All right, and counsel, while she's doing that, I don't have a trial court certification in my
Okay.
file. You do need a test. Urgent. Because I haven't left this seat. And I've been in this seat since 8:40.
Your Honor, I don't have the notes in the documentation.
I've
that
got
I
it.
have.
No. Okay. All right, and can you go over the trial court, while she's doing that, can you go over the trial court certification with your client? Oh, and please don't check off boxes.
Okay,
I don't know why people think they're in charge of checking off boxes when I'm signing on it.
all right. I'm sorry, Judge.
That's
I
okay.
already did. Oh, we get a new one?
Yes, please.
Okay.
Have you signed it?
Sorry, Judge.
Okay.
For the front.
I can fill out your style.
Okay.
All right, move back on your record, on the record. That's your next question.
With looking at the chronologicals, be able to, well, I guess it wouldn't necessarily refresh your memory, but it would see what a previous probation person has considered.
Yes.
So what's the question?
She needs to refresh her memory.
Well, no, I mean, what's the question?
Is the same as, if, you know, is there any indication that Mr. Lopez raised his voice, any indication that he cursed at probation, or that he did anything that would be considered impolite, specifically beyond arguing about his understanding of the conditions?
And this, oh, he hasn't shown it to you.
So based on the notes, it does not indicate that Mr. Lopez first at the officer or
Did he insult the officer?
or what did insult. It does not indicate that he was insulted. It just indicates he was argumentative in regards to the terms of probation.
All right, any other questions?
Right, and we're talking about we talked about zero tolerance, but it doesn't. The motion to adjudicate does not indicate any particular violation of the zero tolerance. Is that correct?
It's in particular to a specific condition.
Into any specific action under condition 22.
Well, zero tolerance is number 22.
Right,
so-
but it doesn't say anything in particular that Mr. Lopez did to violate that. It would be violated zero tolerance to wit, specifically what?
It does not state that on this piece of paper.
Okay, thank you. Now, generally speaking, whenever you're on probation and you break a condition of probation, that is grounds to revoke. Is that correct?
Yes,
So in effect, every probation is zero tolerance to a certain degree.
no,
So you're saying there are conditions where someone may break a condition and that is okay with probation?
it's not okay with probation. It is submitted to the court, and then depending on the court's direction, we go from there.
Okay. Past witness, Jeff.
All right, thank you. Are there any other witnesses from either side?
No further questions for this one, Mr. Chair.
Any other
All right,
witnesses?
phone line.
I'm sorry, before we rest on our case, we'd ask the court to take judicial notice of contents of the court's file, particularly the last two motions to revoke that were filed in this case.
All right, the court will take judicial notice of that.
Defense calls Roland Lopez.
All right, can you raise your right hand for me, please? Do someone swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? Right, can you lower your hand, state your name for the record?
Roland C. Lopez.
All right, defense.
All right. Mr. Lopez, were you ever given any notice to do a drug test on June 30th, 2022?
No.
And how long have you been working at Freeman Expositions?
February 28th, 2017.
And have you changed employment since then?
No, sir.
And how your work goes, if they told you you had to drop everything and do a drug test, would you be allowed to keep that job if you did that?
No, with the prior states, they told me that just the duration of a lot of stuff that went from drug court to everything else, there was a lot of time gaps in between, so I'd have to give them notice to the union and the union give them notice, so they would give me 2 days off, so I could take care of all that situation.
And otherwise, you'd be working every day.
Yes,
How many hours do you do a week?
with overtime and everything, probably over 40.
Okay. And you need to provide for yourself and your family, right?
Yes,
How many children do you have?
3.
And you understand that it is important for you to do everything you can on probation, right?
Yes,
And do you regularly submit to drug tests?
yes,
And you regularly test negative, right?
yes.
Now, if there are times when they ask you to give a drug test, and it conflicts with work, what do you usually do?
I asked to see if I could set it up through the month and say if within that time frame, do I have the whole month to be able to submit, and then I could go ahead and give my job an opportunity to let me off for that date, because there's only one specific place, was RMS, that we could go to, that the probation only lets us go to. And every time they're always backed up, and Sarah Thatcher was a last PO that I had, and she was the one known about this, and she would tell me, you know what, understand, go ahead. Sarah Thatcher was under knowing that I had to do this with my job prior and everything else. And when I got off of probation, back on probation last year at the same time, I was put under 3 months weekly UAs, and everything would be held in advance of SAP and the year deal. year extension, and I completed it completely in May. And Sheriff Thatcher told me not to go I was done with UAs. And
Sustained.
Okay. Now, let's talk about whenever they did extend you. Did you ever get a copy of that extension?
Through drug court, I did.
Okay. And did that and did you comply with that extension, even though it continued after your original probation would have ended?
Yes.
Okay. Now, after you did those weekly UAs, how long did you do those?
I did 3 months weekly, and I did 2 times a week. It was on the audio, the phone UA.
Okay. And Ms. Thatcher told you once you did those 3 months that you didn't have to do it anymore.
That satisfied the judgment from his Judge Boyd the last time putting me back on there. And then she told me that I didn't have to do no more UAs and my stipulations were done because that was the judgment at that point.
Okay, so when Ms. Cisneros took over and told you that you wanted more UAs, you were confused.
Yes, because I was already past my 4th year of probation, and I thought it had been held in advance. So I completed it. I thought it was terminated.
And it did say on that extension that certain conditions were being held in advance.
Yes.
And did anybody explain to you what that meant?
Yes, they did.
And for your understanding is that once you finish those weekly UAs, you no longer had to provide these samples.
Yes, and that was through drug court.
Okay, and you hadn't cleared it with work that you would need these times off for when they requested you do these drug tests, right?
Mhm.
Yes.
Yes.
Okay. Now, you provided me with a copy of your latest check stub from January. Is that correct?
Yes, sir.
All right. And this is a picture of it. Is this a accurate, fair and accurate depiction of your last paycheck?
Yes.
Okay. Now, it doesn't show the whole thing, right?
No.
Right, that's just. But it does show your employer, it does show your name, is that correct?
Yes.
All right, tendering to opposing counsel. And Judge, show if I may tender to the court.
Was there any objection?
We object to relevance under 401 and 403 grounds.
Right.
Saying this is proof of his employment, Judge.
All right.
Judge, we object, there's no date or any kind of indication about when this was.
All right.
And Judge, that's the nature of the photo. I have it on my phone. I can certainly show the court and
All right.
opposing counsel.
Just mark it. I'll accept it. Defense exhibit number 1 is admitted.
Thank you, Judge.
Oh, you need to have it marked too.
Yeah. And again, you said that you've been employed there for the last 6 years?
Yes, sir. Going on 7.
7.
Yeah.
Okay. Now, so you were unable to submit on short notice on the 17th or 18th. Did you submit a drug test within the month of November?
Yes, sir.
What day?
This will be the 30th.
Okay.
And I had asked at that time of the 17th, I had Ms. Cisneros, if she would supply me with her email so I could get all the receipts from the UA and my home, my ID, and whatever I need to present to her. And I never got that email.
Ms. Cisneros never gave you an email so that you could report to her all the things that she's accusing you of not reporting?
Yes, sir. No, she didn't.
Okay. Now, on about the 13th day of July 2022 and November 17th, 2022, did you have Zoom meetings with your probation at the time?
Yes.
Okay. And at the time, did what they say to you conflict with what you were told by Ms. Boyd and others and your previous attorney as to UAs, making payments, et cetera, et cetera.
Yes,
Okay. And did that confuse you?
yes, it did.
Did you bring this up with them?
Yes,
Did you raise your voice?
no,
Did you insult them?
no,
Did you curse at them?
no,
Did you do anything besides question whether they were correct about your bond conditions because they had been previously explained to you differently?
no,
Now, on November 17th, did you have a change in address at any time?
no,
And did you have a change in job at any time
no, sir.
on or about the 17th day of November 2022?
No, sir.
Did you-
Counsel, just 1 second. Let me have you guys step back just for a minute, because I have cases behind you that are not going to take that long.
Okay, good.
All right, thank you. No problem. Christopher Davis. All right, where are we on discovery?
Your Honor, there's still a couple of things outstanding. I also wanted to advise the court that I haven't given a plea offer yet, because he does have some federal involvement in this case that I need to collaborate with them on in order to get defense counsel.
All right, how much time do you need?
30 days should be plenty, Your Honor.
Counsel?
Judge, I think that would work. I just want to make sure that we're still moving on the discovery from last time, which was identifying the hand in a particular video as the complainants or not complainants and CPS records. I think those were the two we addressed last time.
Okay, so the hand in the video and CPS records.
I believe it.
All right, so when we come back, Ms. Ferguson, can I have a 30-day reset, please?
Yes, March 23rd.
All right, we're going to come back on March 23rd. And at that time, I'm going to want to update on the identification of the hand at the video and CPS records.
Okay. Understood.
All right, thank you.
All right, thank you, Judge.
Froland Guzman. David Lee Gallegos. All right, court is calling 2022 CR 7880, State of Texas versus David Lee Gallegos. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense.
Carl Alexander for Mr. Gallegos.
Are you Mr. Gallegos?
Yes, Your Honor.
All right, and Ms. Abrams, there is no application on this case. Counsel, have you received all discovery?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Gallegos, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we will waive the enhancements, make it a third degree.
Any objection?
No, Your Honor.
Mr. Gallegos, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
We charged with injury to the elderly bodily injury as a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Gallegos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, ma'am, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am, Your Honor.
Are you a U.S. citizen?
Yes, ma'am, Your Honor.
Court will find that defendant has knowingly voluntarily waived his right to jury trial, showing you the plea. Did you review that with your attorney? Did you understand that?
Yes, ma'am, Your Honor.
According to plea, punishment would be assessed at 2 years in the prison. State will take into consideration CM 105393, NIMAC number 6900807, 2022 CR 7372. There's an affirmative finding of family violence, no contact with Luis, Luis Hernandez, and 1514 Ruiz Street. Did you understand that to be the plea?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
I didn't go over that part, Judge, if I just have a moment.
Sure. Did you understand that?
Yes, ma'am.
Did you understand that to be the entirety of your plea bargain agreement?
Ma'am.
Knowing that, do you wish to continue with the plea?
Yes, ma'am.
Defense, is this the plea?
Yes, Your Honor.
State, is this the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written plea trial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counselor, the name six months
No, Your Honor.
into the offense is charged. How do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
State any evidence?
Your Honor, we offer State's Exhibit number 1 and all attachments.
I've gone over those with Mr. Gallegos, Your Honor. We have no objections.
Mr. Gallegos, I'm showing you what you title waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call on the right to remain silent?
Yes, ma'am.
To understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments are in reader's name. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right, the court will follow the plea bargain agreement. The court will sentence you to 2 years in the prison. Give you credit for any time served. Take in consideration CM 05393, NIMAC number 6900807. 2022 CR 7372. There's an affirmative finding of family violence. There's to be no contact with Luis Hernandez or 1514 Ruiz Street. Is there anything else with regards to sentencing? Did you read the document entitled trial court certification with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, and also because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. How old are you?
36, ma'am.
All right, you're 36. Somebody else is taking care of your children. You got to treat them with respect. They have full custody of your children. That means that you're no longer legally their parent.
Yes, ma'am.
So you can't be going to somebody's house acting like you're the parent when you haven't been the parent.
Yes, ma'am.
If you have a drug or alcohol problem, which it appears from my reading of the police report that you do, you got to take care of that.
Yes, ma'am.
And if you want your children to be proud of you, you got to change your ways. And you're getting to the point where you have more of your life behind you than in front of you. So you better start doing right. Otherwise, you're going to find yourself living at the prison. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Your Honor.
You're welcome. Who's here on Christopher Black? Sean, this is deferred.
It's a silence.
Silence, it's deferred, okay. All right, court is calling 2021 CR 11535, State of Texas versus Christopher Black. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense,
Kelly Piddle for Christopher Black.
are you Mr. Black?
Yes, ma'am.
Counsel, you received all the discovery in this case, and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Black, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor.
I'm sorry, I'm showing you true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We did, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Black, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it at all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of injury to an elderly as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call them the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand that the court grants your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court would sentence you up to 10 years in prison, up to $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defense?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Black, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review it with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 4 years in the prison. There's a $500 fine. State is silent on your application for deferred. They recommend community supervision. There's to be no contact with Robert Garza. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
You understand that?
Yes, Your Honor.
Defense,
Yes.
state.
Yes.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, there being such motions?
No.
Next, I'm showing you outside the plea bargaining agreement, state is requesting that your community supervision be for a term of 4 years. There be 200 hours community service and anger management. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence?
Your Honor, we offer State's Exhibit number 1 and all attachments.
No objection.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you
Yes.
understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witness statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review what's in right, after reviewing states exhibit 1 and attachment support will find there sufficient evidence to find you guilty, the court will defer finding of guilt as you apply for deferred adjudication. All right, is there a reason the state is silent?
Your Honor, I guess the wishes of the victim, without proceeding too much on the silent. We are recommending that he get a conviction for this.
Okay, so other than the complainant asking that he receive a conviction, is there anything else that the court should know about in deciding whether or not to give him a conviction or not? Is there some criminal history that I don't know about?
He has some misdemeanor theft cases, Judge, but no felony criminal history.
Is there any violent history in the past?
I think that's accurate, Your Honor.
All right, you gave up the right to remain silent. What is his relationship with your mom? Because I'm reading this report that you wanted to speak to your mom. The complainant who's saying that he is married to your mom wouldn't let you see your mom. So what's going on?
Pretty much they tried to, well, they lied when they called CPS.
No.
Oh.
We're not going there. My specific question is, what is your relationship with your mother? What is the relationship with the complainant? Because what I'm seeing here is that the complainant lives with your mom or your mom lives with the complainant. They're saying they're married. I don't know if they went to the courthouse to get married or if this is a common law marriage, but they're holding themselves out to be married. And it appears from my reading of the police report, at the time he wasn't living there, but according to the police report, and I'm accepting it as true, he goes over, he wants to see his mom. And then door gets pushed in and the complainant, not his mom, falls back when he pushes the door in and hits a coffee table and scratches his back or has a scratch on his back.
Right.
So I'm trying to figure out what is the relationship here?
There is no relationship between.
No, I mean with the
complainant and
mom. I mean, what is
There-
the family
there-
dynamics?
There's no more relationship.
There's no more,
It's,
Your Honor.
there's a no contact order as part of the plea bargain. We stipulated to that. We have no issue with that.
So why does your mom don't want to have contact with you?
Judge, his mother filed a SAPSR into his parent-child relationship with his son, stating that he should not have custody of his son and he should go back and live with his mother. So she put herself into that situation. And that was what instigated his going over there to have a conversation about that. That is no longer an issue. That parent-child relationship modification has been resolved. And so there should be no problem with the no contact order with the complaint.
Oh, yeah. So any objection to the court proceeding?
Not from the defense.
All right, this is what the court is going to do. All right, court is going to sentence you to 4 years deferred adjudication. There's a $500 fine that will be probated. There's to be no contact with Robert Garza. And where is your client's son now?
He is out of state, Judge.
All right, there's an affirmative finding of family violence. Regular reporting by Zoom or in person. Regular UAs. 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of COVID vaccination. The court is going to require parenting classes. And once you complete those parenting classes, the remaining of the hours will be waived. Anger management. And probation will do field visits for the first 3 months. If there's no problem, then you can cease with the field visits if you so choose. So field visits once per month for 3 months. Probation, is there anything else he needs? Proof of employment within 30 days. No employment as a home healthcare provider or with minors. There's to be no contact with Robert Garza. All right, probation, is there anything else he needs? Is there anything else you need from the court to be successful in this probation?
No, Your Honor.
Judge, do you want us to come before August? He's gonna be moving to Cameron County down south. Do you want me to come with a motion
At that time,
defendant allowed to transfer to Caleb County,
Cameron,
Cameron. In August. Right, so just you need to make sure before you go to Cameron County that you get permission from probation, but I've already put it in the order. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you.
thank you, Judge.
Welcome. Who's here on Jacqueline Wallace? She's only pleading to one case, counsel?
That's correct. The other one's being discussed,
Okay,
and it'll be set for a PSI.
all right. Court is calling 2022 CR 3725B, State of Texas versus Jacqueline Wallace. Could I have parties announced for the record for the state?
Michael Villarreal for the state.
Defense,
John Coons from Ms. Wallace.
are you Miss Wallace?
Yes, ma'am.
Counsel, have you received all the discovery in this case, and did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Wallace, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Wallace, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
All right, did you understand you're charged with aggravated robbery? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargaining agreement with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court grants your application for deferred adjudication, if for any reason it will revoke, the court could sentence you up to life in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe he has a rational, do you believe she has a rational as well as a factual understanding of the charges against her?
I do believe.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes and yes, Judge.
Ms. Wallace, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes.
Are you a US citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her rights to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishments be assessed at 7 years in the prison. There's a $1,500 fine, affirmative finding of deadly weapon. State is silent on your application. They will take in consideration 2022 CR 3726A. And you agree to plea as a co-defendant to Juan Ratana and cause numbers 2022 CR 3725C and 2022 CR 3726C. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in
Yes.
both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Yes, Your Honor. At this time, State Upper States Exhibit number 1 and its attachments.
We've reviewed them and have no objection, Your Honor.
Ms. Wallace, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Do you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding you guilty as you applied for deferred adjudication. Counsel, is there a TAP evaluation or any other things needed?
You know, Judge, I don't believe there's a need for TAP or mental health evaluations, but if the court would like to, just to have more tools at its discretion, that would be fine.
All right, so we'll do a PSI probation and a TAP evaluation. We'll come back on March 30th at 9 a.m. At that time, the court will make a decision in your application to be based upon the PSI report and any other evidence that's presented to me.
Thank
All right,
you.
thank you. All right. On Christopher Armstrong, please. All right, Mr. Armstrong, can you come forward?
Thank you, Mike.
Thank you. Where's his attorney? Armstrong. What's your attorney's name?
I don't know.
All right, just have a seat. We're gonna have you have a seat right in the box. We'll get to you. If you can have that attorney come back here, please. And who are you here for?
Should be a motion on your. And Michael Herrera, but Alejandro.
All right, did you confer with the state on the request to travel?
I believe I did. Herrera? No, I'm Alejandro, to go get a haircut. What was I telling you about?
All right, let me give state, if you can have this motion.
Okay. You got it?
It's family violence case.
He just needs to go get a haircut this weekend. Hold on.
And I'm sorry, Michael, also this motion.
I did confer on Michael
Rare.
Herrera. And actually, does the court have the court file?
Yes.
Okay, in our notes on, in our system, it reflects that the April motion that was presented to the court was actually granted. But looking online, it shows that it was denied by the court, and it was to give him permission to be able to go 1 day a week to go perform household duties. I believe it was April 22nd.
Because anything I sign is will be in the file.
I'm sorry, April 29th.
Yes, it's in here. Defendant is allowed 1 day per week from 8 a.m. to 6 p.m. to complete any
Okay, so in looking on
necessary errands with no unsupervised contact with minors. That's what was agreed to.
Okay, and in looking online, it actually is entered by the clerks that it was denied.
Okay.
So his pretrial service officer is not allowing him to be able to go do that.
Okay, I will.
First
put it in here.
correction. And then the second thing is he's contacted me saying that he also would like to attend church services with his aunt and uncle, which we did confer, and I'm happy to listen, but that's what he asked me.
All right, well, if you all want to set that for a hearing, I'll have a hearing on that.
Okay, that's fine.
Yeah.
One moment.
Can you just go back?
Yeah.
So if you want to get a copy of that.
Thank you. And then, Your Honor, on Alejandro. The state is in agreement.
They're in agreement?
I think we release it every fourth. So the 227 should have one.
Like your memorial.
All right, you all want to come back up on Lopez?
Hey, Judge, how you doing?
Oh, doing great. Been here since 8:40. Haven't taken a break off the bed.
Yeah.
Oh, we need to get a court reporter back.
Oh.
And so while we're waiting for the court reporter, let me take a short break.
Okay, Judge, I do have one issue. I am supposed to be meeting with some movers at my storage place. My oldest son is finally moving out again. And if I miss that, he's gonna have to stay.
Ah, okay, so when is that?
That's it. If at 3 o'clock, that's gonna take me about 45 minutes to get.
All right, so what we'll do is we'll bring this back on Monday to complete it.
Okay.
Is everybody okay with? There are no outstanding witnesses?
Not from the state.
All right, so we'll come back. Norma, can we bring Mr. Lopez back on Monday to complete his hearing? All right, so we'll come back on Monday, Mr. Lopez.
Thank you, Judge.
You're welcome.
Carrie Underwood.
Yeah. All right, Mr. Armstrong. We're gonna wait for your attorney, but you're not leaving the courtroom today.
Sure.
So we're not on the record, but you're aware you tested positive for meth, marijuana, and amphetamine. You're aware of that?
Meth and marijuana use.
All right, so why? Well, I'll wait for your attorney to come.
I'll answer your question.
No, I'll wait for your attorney to come, but you're not gonna be leaving the courtroom today, okay? All right, so we're gonna have you sit in the box, and we'll try to get your attorney. If not, we're gonna take you in custody. We'll see you back here on Monday. Okay.
I'm trying to get it. I'm still trying to get it out. Okay, it's right there.
Can you mute us, please? All right, so Mr. Armstrong. Oh, if everybody could please whisper. Mr. Armstrong, I think it's best if you go into custody. We'll bring you back on Monday. I'll call probation to make sure a TAP evaluation is done for you. Because you end up testing positive for a lot. And I don't think it's best for you to be around an infant. And I think, well, but the problem is, you told me the reason why you needed to leave is because it was your vehicle and there was not a babysitter.
Yeah, I needed to drop them off at their house.
Yeah, so what we're gonna do is we're gonna bring you back for Monday, because I don't want you to leave this courtroom and end up using, because that may be the last time that you use, because you never know what you're getting, okay?
Yes, Your Honor.
So we're gonna make sure that you come back here on Monday. So I'm gonna issue a warrant for you today. And it's just so that you can be taken into custody, and we'll bring you back over first thing on Monday, okay?
Sorry for lying to you, Your Honor.
No, I mean, here's the thing.
I was scared and I didn't know what to do and I know I was dirty and I'm sorry.
Well, I will tell you that people will tell you in this court. I'm just looking for people to be honest, because like I was telling you before, I'm trying to give you conditions so you can be successful. I take no pleasure in sending people to prison. If somebody's placed on probation, I want them to succeed so they can be better in life. Okay. All right. So we're gonna take you into custody today, and we're gonna have you brought back over on Monday. Okay. All right, Norma, can we make sure we get him on Monday?
Yeah, he's on the docket.
All right, so you are on the docket for Monday, okay? All right. Okay, we'll solve it on Monday. All right, and I think we are done for today. At least that's what they're telling me. If we're not, I'm stating it, we're done.
All right.
It's Friday.
Hey, that's all I need.